the court, my former last witness, Kim Martin.
Michelle Martin.
Do you have any objection against taking the oath?
No, I don't.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Raise your right hand and say, so help me God.
So help me God.
Thank you. You may be seated if you so wish.
Thank you.
Madam, you've given evidence in the court before during the trial we had in this matter. Is that correct?
Yes, I have, my lady.
And you can still remember your evidence?
Yes, I do.
You confirm the contents of the evidence you gave?
Yes, I do.
Now, Madam, it's now a year and more later. Do you still think of Reba?
Every single day. Not a day goes by without thinking about her.
How are you coping?
My lady, coping, yes, because you've got to get on with your life. But the scars, the effect runs very, very deep. We'll never completely get over it. But I'm a mother of 3 children. I have to cope. I have to be an example for them. I have to give them hope for the future. They're at an age where they need to be able to make sense of what has happened. So I have to be strong for them. So coping, because we have to, yes. But getting over it, no.
And your children, are they coping?
I try, as a mother, do the best job that I can. They are young and find it very hard to process what has happened. It's been 3 years now since the incident, my lady. And at different stages, I see different effects coming through on my children. I don't want to, for sensitivity reasons, explain exactly what my children have been through, as I did previously, because I've seen the effects on them, but they suffer very much because of this.
Has it changed your life?
Yes, it's changed my life completely. Besides the obvious anxiety and depression, as a family, we'll never ever be able to carry on like normal. You know, just standing in the queue at a shopping centre poses difficulty. You know, people don't recognize you and they start mentioning the trial, or they start mentioning Oscar, or they start mentioning Reva. And you can never be prepared for what might come up. You know, I attended a workshop a couple of weeks ago, a self-awareness workshop. And without the people realizing, the lecturer started speaking about Oscar and his gun complex. And I just went cold. You know, it's never going to leave us.
You, apart from you, your children, the broader family, how are they coping?
My dad, for instance, is... I saw my dad cry for the very first time when Reva died, and I saw him cry for the very second time when he heard that I had to testify again. It's very unfair what our family's been put through. You know, losing a family member that was such a big part of our lives in the way that we did, and then to have to be exposed to the media, to have to sometimes defend ourselves, it's very difficult.
Talking about media, do you know anything of an interview that the accused gave to the media?
The only thing that I do know is what I've heard on the radio and TV, that he's going to be doing, what he's done in an interview, and that it's going to be viewed on the 24th of June.
And how do you feel about that?
I'm not happy about that at all. I just think it's very unfair to want to talk to the world about your version when you had the opportunity in court to do so. And it's just, it's hurtful. I just don't understand why. I can't understand why.
So, as a family, you have Christmases and birthdays. How does that affect the family of Rebus?
It's terrible because we want to be there for each other. We want to be able to celebrate. And for me, for my children, I can't let every special occasion be about Reba being murdered, about not saying anything. We have to celebrate. We have for them, you know, my youngest daughter is 17 years old. She doesn't deserve to have every special occasion cut short. As it is, Valentine's Day is the worst day for us. Christmas, we all want to be together, but we're also scared to mention something. We're going to set somebody off. We want to honor Reva's memory by leaving seating, like we said, by putting the candle out for her. But we don't want every occasion to become a funeral, you know?
And your Uncle Barry, how's he coping?
As far as I'm concerned, my uncle is a broken man. You know, he lives day to day on his phone, just watching the posts about Reva. The guilt, as a father, not being able to protect his daughter. It's very difficult for him.
You've said during consultations that you expected something of the accused from the start. What was that?
I didn't hear your question.
You explained that you expected something from the accused from the start of the trial. What was that?
And my lady, all we've ever wanted is the truth. And I know people said, but you got the truth, but we didn't. Oscar's version changed so many times. And I never ever heard him saying that I apologize for shooting and murdering Reva behind that door. I don't feel there was an apology from him. I don't feel the true version came out. We just wanted the truth. That's what we wanted.
Thank you, my lady. Nothing further.
Yes, Mr. Van.
Thank you, my lady. Ms. Martin, I was very, very careful when Mr. Steenkamp gave evidence because I understand the pain. But there comes a point that I have to draw a line. And where we also must focus on what's going on with the accused in this matter. And I've unfortunately reached that point. I'm going to read to you some transcripts and some interviews, including one of yours.
Okay, may I sit down?
Yes, of course.
Thank you.
And I will demonstrate and later argue to the court how everyone either did not know what was going on in the relationship or experience his relationship with the deceased as a good relationship. But then, after hearing rejected evidence in this court and media publications about rejected evidence, then suddenly he became the villain. And I'm going to take you through it. What was before this court in the bail application, and I just want to deal with the relationship between the accused and Reva, the deceased, and how it was experienced by a close friends. Samantha Gravenstein, that was undoubtedly her closest friend, described this in a statement that's part of the record. After saying that Riva was her best friend, paragraph 7. After a while, Riva and Oscar started dating. Riva told me that Oscar was amazing and he treated her like gold, and that she thought they had a lot in common. Riva told me she really liked Oscar. The relationship slowly progressed and became more serious. Riva often mentioned how happy she was and that Oscar made her feel that way. And I want to read the second part to you, and then I will go also to what Gina Myers, another best friend, was saying. Paragraph 9. Riva confided in me that even though she and Oscar had not been together for very long, she really loved Oscar and she could see a future with him. She told me that if Oscar asked her to marry him, she would probably say yes.
Sorry, my lady, was this still Sam Gravenstein saying
That's
this?
right.
Okay.
Do you have any comment?
Yes, first I'd like to say that I didn't even know Sam Gravenstein, so she might have been quite close to Riva at the time, but I didn't know that she was even a friend of Riva's. And I asked Riva, and I was very close to Riva. Riva and I were like sisters. I asked her, "Are you happy?" And she said to me, after shrugging her shoulders, she smiled and she went, "We will speak later." I could see she was bubbly. I could see she was excited. And I could see there was a fondness for Oscar, but I did not see any love. So Riva had opportunity to tell me that she loved Oscar, and she never did. We spoke over WhatsApp.
Is that as far as Riva went in discussing Oscar with you, to shrug her shoulders?
When I asked her, when I questioned her feelings for Oscar,
Yes.
and I questioned her happiness, that's as far as she went, yes.
And that's where it stopped.
Yes.
We'll get back to it.
Okay.
And we'll get back to an interview that you gave
Okay.
and your previous evidence. And then you will see why I said in the beginning that I'm sort of concerned. Another friend also wanted to be described as a best friend was Gina Myers. You know her?
Very well. As far as I'm concerned, she was Riva's best friend.
Yes. There are 2 interviews, live interviews. The one was with Mandy Wiener on 27 February 2013, so shortly after the event. And I'm going to read the question to you, and I think you can accept what I say, otherwise we'll play it. And how did she feel about the new relationship? I can tell you that was a reference to Mr. Pistorius. Answer. She was happy. I think in every relationship there's ups and downs, and you know stuff that you go through when it is a new relationship. But everything was normal. Let me read the second one.
Who was she interviewing? Sorry.
She gave an interview to Mandy Wiener.
No, who was?
Gina Myers.
Okay.
You want to comment on that or wait for the second one?
No, wait. Thank
The second one was with Andrew Harding of the BBC. Same day, 27 February 2013. Question. Do you think Riva was happy? Answer. I did. And in a relationship? Yes. Any comment? You don't have to comment. Ask if you have any comment.
Yes, I know. Thank you. I can't speak for Gina, my lady. I've heard lots of things about how Reva felt about Oscar. I don't really know what the point is. I mean, yes, I know she liked Oscar. I don't think she loved him. I think she was very fond of him. I think she had a very soft spot for him. I can't comment on, I don't understand what you want me to comment on
No,
their feelings.
It's just
Yeah.
a decent thing to do.
Okay.
Now, you said previously in your evidence that when you asked her about the relationship, she really didn't tell you, she shrugged her shoulders. And you would talk later, but that occasion never occurred.
Correct.
Is that correct?
Correct.
So you don't really know what was in the relationship?
Correct.
Yeah. Can I remind you what your previous evidence was? And it concerns me, because the court must work on this. At page 3647, and then I will go to an interview that you had with Pierce. You were asked about it. You explained at the bottom of 3647. You explained that when Reva was an adult, she was living in Johannesburg. She confided in me what that relationship, what it was about, and what it had done to her, and how it affected her, and to what extent it was, how abusive it actually was. That was your previous evidence, and we know now you could not say that.
What relationship are you speaking about?
I object, yes, my lady. We should make sure that we're talking about the relationship with Oscar, because it's not.
Well,
That's not. I never said that about her relationship with Oscar. I said that about her previous, one of her very first relationships.
well, if you're right, then I will apologize, because I'm reading it here. You say, do you say that had nothing to do with Oscar?
That had nothing to do with
Then I
Oscar.
apologize. Then it's wrong. My understanding then is, and I really apologize, then it's a wrong reference to it. Let's go to the interview. Can you remember that you had an interview? It was aired 20 February 2013, shortly
I remember
after the
that
event.
Very clearly, yes.
And you were asked about this, and you said the following: would this be correct? When did Reva tell you that she was dating Oscar Pistorius? Can you remember that?
Okay.
That was the question, yeah.
Yes.
You don't have.
Okay.
And you answer, well, I saw it in the news first, and that was about only 2 months ago. When it first came out, there was rumors. When she attended one function with him, and I remember I sent her a message, and I said, is it true, cuz? And at the time she said no, but he's a very nice guy. And that's basically it. She never really spoke much to me about him other than that. Would that be correct?
That's correct.
So all that you really know is that she described him as a nice guy. And that's as far as it went.
Correct.
You know about the Valentine's card that she made for him saying, I love you?
Other than hearing about it in court, no.
I have no further questions, thank you.
No re-examination.
Thank you very much, Mrs. Smart, for your assistance. You may be excused.
Thank you.
That concludes the evidence for the statement.
Thank you very much. Yes, Mr. Roux,
I'm so sorry.
do you want to call any more witnesses?
No, my lady.
You don't. Are you ready to argue?
We're ready, my lady. May I just, 1 minute just to get copies of the heads of argument? And then may I just hand to you a copy of our head's argument, and what I've done, I've prepared a separate bundle for the annexures there too, otherwise it's too voluminous and it's difficult to deal with. I will also, at the right time, it's just because I don't have it in my hand, give you the copies of the cases that we referred to, just as a matter of convenience, my lady. Here it is.
Yes, Mr.
My lady, just to explain to you the format of our heads of argument, we took your judgment and then compared it to the judgment of the Supreme Court of Appeal to see what is different. And then at the end you will see we come to what we call the distilled facts, meaning what facts remain undisturbed and what is new and what is that complete picture, in order to try and present to you a complete picture based on a reconciliation between the two judgments, because it was not too difficult to reconcile them, as you will soon see. But before I deal with it, if I may say this, lady, there are serious enemies, so to speak, in this matter. And the first one is that there was a perception created that the deceased wanted to kill the deceased. That direct intent theory. And it does not go away, because once you have created a perception, some people who wish to be informed and who wish to sit back and analyze the facts and put their trust in the court would then consider, was it really true that he wanted to kill it, that Dole's directors? Or is the finding very different because we know now the objective evidence, and I'll get back to that. And is it not perhaps a different picture? And to what extent has that different picture changed? It doesn't happen in this case. Sometimes understandably so, sometimes not. Understandably so when you have a father that's hurting, and what's in his mind, because what was put in his mind is there, and it's not for me to cross-examine him on the court's findings. You can only have empathy and sympathy with the parents. But the unfortunate part is that hurt, that pain is aggravated by perceptions created in this trial. That's the unfortunate part. The second one is, the second enemy in this trial is, there is from some part of the society an unwillingness or an inability, I don't know which one, to see this accused in the context of that evening. He's still portrayed in their minds and somewhere in the media as this person winning gold medals, the strong, ambitious person, 1.84 meters. And that would have the effect that the real facts become concealed. That takes away the real context, where it was not the man winning gold medals that must be judged. It is common cause. It was a 1.5 meter person standing on his stumps, 3 o'clock in the morning when it was dark. And once you start and want to see it, of course a very different picture would unfold. But if there's resistance to accept that, then of course it would so perfectly attach to the "I wanted to kill the deceased" theory. The third one is, once you have bad emotions about the case, like the emotions, the negative emotions caused by the first two perceptions, then many people have either an unwillingness or an inability to set the bad emotions aside and to look at the true facts and to say, but what really happened? Instead of saying, I don't believe it. I don't believe it means I don't believe times on cell phones. I don't believe other objective evidence that I will come to. Not things that people thought, objective evidence, we've dealt with it in a timeline. I distinctly remember this court asking the state, can you deny that? There could not be a denial. They were objective grounds. But if you allow perceptions to control your thought process, you would not even pay any attention to objective facts, to objective impossibilities. And that's the difficulty in this case. Those factors, and whatever sentence you impose, there will always be a group of people refusing to allow the true facts as found by the court, and for this instance the courts, to rather prescribe to them and to their emotions what an appropriate sentence should be. There can never be an appropriate sentence if you believe that he had an argument, he wanted to kill her and she ran to the toilet and he killed her, which are not the facts. Not because we don't think that they are the facts, because those facts were absolutely refuted by objective facts, not by say-sos. But I understand it in some instances when you go through pain. I understand it. I don't always understand it for people more removed, why they don't want to sit back and look at the true facts. The fourth one, the fourth enemy is, and I've unfortunately seen this in different contexts, is that we have a concept in the criminal law that we call benefit after doubt. But what we then see when it comes to whether to convict or not, that the court very correctly, because the court is trained in that process and experienced in that process, say, well, you may have done it or you may not have done it, and it's not as fanciful possibility. I have a reasonable doubt, not a fanciful doubt, not just a distant possibility. I have a reasonable doubt that you didn't do it. But then when we get to sentencing, there's sometimes, and very much also in the minds of lay people, this perception that, but hang on, maybe he did it. And then you can't just sentence him because you have doubt. Maybe you must include a couple of years for that possibility, for that doubt. So the doubt becomes then the aggravating factor. Without saying to yourself, but hang on, how can I add years? How can I ask for a more severe sentence? If the reasonable possibility at the very least, if not the probability, is that he didn't do it. How can you add years? How can you now say, well, maybe he did do it and I'm going to punish, or I want him to be punished more severe. Those factors, those four enemies, remain in this case. Whatever I'm going to submit to this court, whatever I'm going to say about your judgment and the Supreme Court of Appeal judgment, they will never disappear unless, not this court, society, unless the members are prepared to say, should I not just sit back and think for one moment that there might be another version, and it might be true, and what then? What if it is so? What would I want then to happen to this man? And the brilliant example that we have, most of us remember that very, very tragic incident of Vleis Versace, a well-known rugby player, where he saw sometime late night his car driving out, living on a plot. And he thought someone was stealing the car, and he fired a shot, and it was his daughter, and it killed her. It was not right to fire the shot. Of course not. And if you analyze it in view of the Supreme Court of Appeal judgment, when he at the very least foresaw and reconciled with the possibility that he could kill that person, it's murder dolus eventualis. But everyone sympathized with him because they understood, and he was not prosecuted, if I may add. He was not prosecuted. There's a statement by the prosecuting authorities to say, it's not right to prosecute him, it's inappropriate, and I agree. But that's not the point that I'm making. I'm not asking for a non-prosecution. But everyone understood that you can make a mistake where you shoot at the person under a mistaken belief, and that you're law then guilty because you still shot at a person. But then there comes this little tail back to it, and it's again converted into he wanted to kill the deceased. Everyone in the Vleis Versace understood, and when you ask everyone, they would say, it's terrible. It's of course terrible. I think so often about him. How must you feel when you know you should not have fired that shot at your own daughter? But maybe not exactly the same class. But how must you feel when you fire those shots that you should not have, and it's your own girlfriend? But that privilege, that thought process, in some instances, remain absent. And what do? We criticize without sitting back and following the process. And that is what we try to do in the heads of argument, my lady, where we say, you have a number of questions to answer. The first is, of course, that the prescribed sentence, the discretionary sentence, as they call it nowadays, that it is 15 years for murder, unless, of course, you find substantial and compelling circumstances. And we will take you through the heads of argument to explain why we say there should not even be an argument that those substantial and compelling circumstances are present in this case that would allow you to deviate from the discretionary sentence. We say to you, and we refer, and that's page 3 of our heads, my lady, we refer you to the Malgas case, and then a very, very useful application of the principles in Malgas in S versus Vilakazi. And what it really tells you, in short, and you've heard it so many times, my lady, and I'm sorry to repeat that. It says that, and I go to page 3 of Malgas. The first one that's important is paragraph 9, where the Supreme Court of Appeal said the following: I can see no warrant for deducing that a legislature intended the court to exclude from consideration ante omnia, as it were, any or all of the many factors traditionally and rightly taken into account by courts when sentencing offenders. So it's not that you must now suddenly show something new, something extraordinary, something special, something exceptional. It's not true. And it is so well put in paragraph 22 of the Malgas case. And that only a court can understand, because a court is trained in law and in experience to understand that feeling that you get. When you look at the facts, you get that distinct feeling, this is more or less where I should go. And it tells us what that feeling is. It says, the greater the sense of unease a court feels about the imposition of a prescribed sentence, the greater its anxiety will be that it may be perpetrating an injustice. Once a court reaches the point where unease is hardened into a conviction that an injustice will be done, that can only be because it is satisfied that the circumstances of the particular case render the prescribed sentence unjust, or, as some might prefer to put it, disproportionate to the crime, the criminal and the legitimate needs of society. And I submit that there must be an unease when anyone tells you must send Mr. Pistorius 15 years to jail, where it's a man that was on his stump 3 o'clock in the morning who did not want to kill his girlfriend, who believed, and I will show you later, that this finding by the court is undisturbed, who believed that she was at the time in the bedroom. That's undisturbed. Do you send that person 15 years to jail? How is that so far removed from Vleisversagie case? How is it? There are differences, but is it so far removed that the one should not be prosecuted and the other one must be sentenced to 15 years? We submit that unease and that anxiety must be overwhelming in this case. And that only would indicate one thing: it cannot be. It cannot be, provided, and this court has done it, provided that you prepare to entertain the correct facts and not to be drowned by the many perceptions, provided that. Because if you allow yourself to be drowned by perceptions, by wrong facts, any sentence will do. The same was then said, I refer to Vilakazi, and I've underlined in paragraph 15 on page 4 that one part where it says, with reference to Malgas, that the provisions of the Act vest the sentencing court with the power, indeed, the obligation to consider whether particular circumstances of the case required a different sentence to be imposed. And a different sentence must be imposed where the court is satisfied that substantial and compelling circumstances exist which justify it. I'm not going to read all of it. It is there on page 5, my lady. I will then go and ask you to go to paragraph 6 of the heads of argument. Page 6, my lady, I'm sorry. It says the SCA judgment. And we say to you, my lady, that when, for the purpose of this case, when considering, just the abbreviation, the Supreme Court of Appeal, it's no disrespect, I have huge respect for the Supreme Court of Appeal, of course. When considering the SCA judgment in relation to the present sentencing proceedings, it must be borne in mind that the SCA did not reconsider the merits of the case, but considered questions of law relevant to dolus eventualis and error in objecto. As such, we say to you, my lady, that the legal and factual basis upon which this honourable court relied for the imposition of sentence remain valid unless different findings apply as a result of the SCA judgment, and then only to that extent. We submit, my lady, that it's in this context that the SCA judgment must be considered and applied to the undisturbed factual findings and sentence considerations made and applied by the trial court. What we then do, my lady, we then proceed to the SCA findings. So we first isolate them, and you will then see a later process where we combine them and say, well, let's look at the trial court's finding and to the SCA finding and to see what the position is. Paragraph 13. The SCA found that in discharging the shots, the accused acted with dolus eventualis. And let's immediately say, not dolus directus. There is nothing in the SCA judgment saying there was an argument, saying that you ran to the cubicle, saying that he wanted to shoot her. That's not this court's case, and it's not the case in the SCA. It is a very different case. And before I read to it, in short, it is this. When he fired the shots, this court was of the view that he was genuinely in fear of his life. And the fact that he did not fire chest high but lower had this court in a position where the court had to consider, would this now be culpable homicide or dolus eventualis? And the court very carefully considered the two and ultimately came to the decision, because of the subjectivity of the mind, that it was culpable homicide. But when it came to sentence, the court made it plain and clear that, and it explained to us that process that the court must have gone through, that whatever I found, it bordered on dolus eventualis. So we're really talking here on a difference in view whether it bordered or whether it was. And that's all. So the SCA found then, we say in paragraph 13, the SCA found that the trial court had concluded that dolus eventualis had not been proved premised upon an acceptance that, as he had thought Riva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that the accused did not realize that it was Riva in the toilet. He did not foresee that his action in shooting could cause her death, and he could not be held guilty of her murder. The SCA found that the above finding went to the heart of the first question of law reserved, i.e. whether the principles of dolus eventualis, including so-called error in objector, were properly applied. And the SCA found then in this regard, what was an issue therefore, and this is so important, was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. This is so important. We will show you later. You're finding that he genuinely believed at the time of firing of the shots that Riva, the deceased, no disrespect, absolute only respect when I refer to her, was in the bedroom, is undisturbed, not reconsidered. So how, when I look at Vleis Versace, when he thought it was a thief driving away in his car, he also had a mistaken identity. The mistaken identity is not wrong. It's not taken away from the accused. It is a legal principle to say it does not help you in law because you still fired at a person, notwithstanding the fact that you genuinely believed that the deceased Riva was in a bedroom. But what do we have now? We get this impression that the SCA judgment is now that he wanted to kill the deceased, that he did not believe that she was in the bedroom at the time of the firing, that he did not believe it's an intruder. That's not right, my lady. It is so wrong. That is not the finding of the Supreme Court of Appeal, and it was not the purpose of the appeal before. They made it clear that they're not there to reconsider your factual findings. It was on that one aspect, and I'll come to that where they then deal with it. In 13.3, the SCA further found in this regard, what was an issue therefore was not whether the accused had foreseen that Riva might be in the cubicle when he fired the fatal shots at the toilet door, but whether there was a person behind the door who might possibly be killed by his actions. The accused incorrect appreciation, that is so important, it's there. The accused incorrect appreciation as to who was in the cubicle is not determinative of whether he had the requisite criminal intent. There is his incorrect appreciation. It's not rejected. What was his incorrect appreciation? His incorrect appreciation was twofold. One, that the deceased was in a bedroom at the time, and two, that an intruder was in the cubicle or toilet. That was his incorrect appreciation, but in law it did not help him. It goes on. Consequently, by confining its assessment of dolus eventualis to whether the accused had foreseen that it was Riva behind the door, the trial court misdirected itself as to the appropriate legal issue. Then paragraph 13.4, The SCA further found that the trial court's finding that if the accused had intended to kill whoever was behind the door, he would have aimed higher than he did not assist the accused, as it was inevitable that a shot fired through the door would almost certainly have struck the person behind it. Vleisversagie. When you fire at the car when the person driving it, likewise, inevitable. That would almost certainly strike the person. Consequently, that's paragraph 13.5. The SCA found, in these circumstances, I have no doubt that in firing the fatal shots, the accused must have foreseen and therefore did foresee that whoever was behind the toilet door might die, but reconciled himself to that event and gambled with that person's life, not Riva's life. That person's life. This constitutes dolus eventualis on his part, and the identity of his victim is irrelevant to his guilt. Then, as to the defense of putative private defense, the SCA found that the defense of putative private defense implied rational but mistaken thought that even if the accused believed that there was someone else in the toilet, his expressed fear that such person was a danger to his life was not the product of any rational thought. So what the Supreme Court of Appeal says, and we'll deal with later, he says, although frightened, I just don't, your fear that you thought that you could fire the shots was not rational. And I'll come back to that, how you should approach this in sentence, where the case law tells you, when you deal with sentence, then you become far more subjective. And then you look at a person's subjective mind. And we will deal with that when we deal with his vulnerability. And further, although he may have been anxious, it is inconceivable that the rational person could have believed he was entitled to fire at this person with a heavy caliber firearm without taking even the most elementary precaution of firing a warning shot. And that was the criticism, says, you should not have fired. You should. But that does not mean that he did not believe that Riva, the deceased, was in the bedroom. That does not mean that he did not believe it was an intruder. It is just that it was not rational and therefore not genuine to believe that he was entitled to fire the shots. That's it. No more, no less. The SCA found that this constituted prima facie proof that the accused did not entertain an honest and genuine belief that he was acting lawfully. Interesting words. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, most certainly no one's going to say that he was frightened of Riva, the deceased. For the person still not wanting to believe this, are they saying that he was frightened that she attacked him? What would the thought process be? There cannot be such a thought process. Who was he frightened of? The deceased or an intruder? It's only one person. It's 3 o'clock in the morning in the dark. There's only one person that you could be frightened of, or perceived person, an intruder, not your own girlfriend. So I read again. As such, the SCA found that although the accused may have been anxious and although the accused was frightened, the accused fired without having a rational or genuine fear that his life was in danger and the shooting was lawful. Mr. Versace, firing the shot. He could not have a rational fear that he was entitled to shoot and that his life was in danger. The person was driving out. The person was driving out, but there we have the sympathy from some part of the public. There we have the sympathy. He made a mistake, but not Mr. Pistorius. No, I will come back because of all the wrong evidence and the refusal to accept a proper analysis of the evidence, to show the impossibility and the unreliability of that evidence, they stick to it. We say then, and then the court found, obviously, the Supreme Court of Appeal, that the defense of putative private defense could not be sustained. And then it follows that there must be a conviction not of dolus directus, but dolus eventualis. We respectfully submit, my lady, that what we then do, we say it's necessary to reconcile the findings of the trial court in judgment and in sentence with the above findings of the Supreme Court of Appeal in order to consider a just sentence. Factors which arose subsequent to the original sentence must also be considered, and then that proposed sentence must be blended by the well-known concept in court, and that is concept in imposing sentences, and that is the concept of mercy. We deal with moral blameworthiness, and may we make this submission. Once you have reduced moral blameworthiness, I cannot think that any court would say you qualify for the minimum prescribed or the discretionary sentence. Because factually, it's wonderful that you have remorse, and it's wonderful that you have 5 children to look after, and that you go to church every day, and that you donate money for charity. They're additional smaller factors. What is really important in a case? You look at that person's moral blameworthiness to determine who is it that I'm dealing with. You get this person, he rapes a 3-year-old little girl, and you ask him why, and he doesn't want to explain to you, or he doesn't give you a reason, or he just did it because he wanted to do it. You understand the moral blameworthiness and the total absence of a reduced moral blameworthiness. And you compare that with a person that's 1.5 meters high, 3 o'clock in the morning in the darkness, and he thought, incorrectly, that he's firing shots at an intruder. And you say, can you mention it in the same breath? And you immediately realize that per se, we're dealing with a reduced moral blameworthiness, and per se we get that when we deal with dolus eventualis, because dolus eventualis only means one thing. I did not really have the direct intention to kill that person. Not that evil intent, not that murderous intent. It is rather what you foresaw and you reconciled this. It's a further step down. It's softer, with a harsh result. But the moral blameworthiness is softer, my lady. We refer you to the case, we say, when considering the moral blameworthiness of the accused for purposes of sentence, a court must look solely at what an accused believed, because we're dealing with sentence now, my lady, not the conviction, and intended when deciding whether he had reduced moral blameworthiness. We refer to Ferreira and others where it says the criterion for determining moral blameworthiness, it is said, is subjective. This means that one must look solely at what an accused believed and intended when deciding for purposes of sentence whether moral blameworthiness has been reduced. Substantial and compelling circumstances would seem self-evidently to reduce it. It seems to me that the true question to be answered is whether the threat from which each sought to escape was still subjectively perceived to be real and present danger, albeit, and it's so important, not imminent enough to escape criminal liability altogether. This could have been the Pistorius case. At the time of the offence, I say so, and then it goes on to the facts, which are not too important. That's the Mate case, and also Trajan's. Now, what we do, we say, now let's shift the focus to the trial court's finding, and it's no disrespect when I refer to this court as the trial court.
Well, it is the trial court.
Yes, it is, but
Yes.
I mean, I should every time say the honourable trial court, but it's just for purposes of short sentences. So would you please read in, I say it softly every time, lady. The trial court accepted, and we've got the judgment here. The trial court accepted that at 3 o'clock, the accused heard a noise, which sounded to him like the bathroom window opening. He believed an intruder had entered the house through the bathroom window. The trial court found, and I quote, "The bathroom window was indeed open, so it was not his imagination at work when he thought he heard the window slide open. He armed himself with a loaded firearm and went to the direction of the noise." I still quote, "He heard the door slam shut. The toilet door was indeed shut when he fired 4 shots at it after he heard movement inside the toilet." Now the important part, my lady, with respect. These findings remain undisturbed by the Supreme Court of Appeal. It was not the duty of the Supreme Court of Appeal in a question of law to reconsider your facts. It did not. These findings remain undisturbed. The accused approached the bathroom in the belief that an intruder had entered his house. He did so, and that was his evidence to protect himself and the deceased. That protection that he wanted to protect the deceased, that's now gone. He's now a villain. Because the perception is the Supreme Court of Appeal said he murdered the deceased, without saying what are the true facts. I say again, the Supreme Court of Appeal did not correctly so, not reconsider this finding. 2, the trial court found that when proceeding to the bathroom and at the time of the shooting, the accused believed that the deceased was in the bedroom. The Supreme Court of Appeal did not reconsider the trial court's finding at the time of the shooting that the accused believed that the person in the toilet was an intruder and that the deceased was in the bedroom. The fact that the accused is criminally liable on account of dolus eventualis and by applying the principle of error in objecto does not mean that the accused foresaw that it was the deceased in the cubicle and that he reconciled himself with that. That is clear. I've dealt with that. It was pointed out. The accused's actions remain goal-directed to protect himself and the deceased, and the fact that his actions did not meet the legal criteria for a defense of putative self-defense does not mean that his subjective state of mind was not that it was an intruder in the toilet and not the deceased. That remains. As was stated in Ferreira, the true question to be answered is whether the threat was still subjectively perceived to be real and present danger, albeit not imminent enough to escape criminal liability. The accused believed that it was not the deceased in the toilet but an intruder also does not defy logic. I say this just, we say this by the by. It's not that you come and tell me something that is so absolute nonsense, so illogical that it does not make sense. And we say, who else other than an intruder would have entered the house at 3 o'clock? In your mind, when you hear that noise in the bathroom and you believe that it's not the deceased, who else would enter 3 o'clock? Someone coming to clean the house? Someone coming to buy the house? Or who? We know where we live. We're fearful. You would, a logic thought process would be an intruder. Furthermore, we say, my lady, his belief that it was an intruder in the toilet was supported by his actions when he realized that it was the deceased in the toilet. This was further confirmed by his actions thereafter when he frantically took all possible steps to try and save the deceased's life. The trial court found that the seemingly incongruous conduct of the accused to go to the bathroom instead of taking evasive action, if I may say, my lady, with respect, the trial court was in this privileged position to see, to hear, to feel, and analyze every bit of evidence. And the court found it was explained by Professor Adjournment as a fight as opposed to a flight response. The trial court correctly rejected that as a defense. Correctly so. We didn't appeal it because we thought it was correct. But that does not mean that it doesn't explain his actions. The trial court accepts that the accused, that's the finding of the court. So let me read it correctly. This court accepts that the accused is a fight rather than a flight reaction person, as Professor Adjournment testified. We say that the Supreme Court of Appeal did not reconsider this finding, and the finding remains. We say it demonstrates that when the accused proceeded to the bathroom, he was not driven by evil intent. We so many times deal with that concept of evil intent, where I wanted to say where I don't like my junior, but I thought that would be close to the truth, my lady. I'll get someone else. But I say I don't like a person, I'm going to kill that person. That's evil intent. The trial court found. This court also accepts that a person with general anxiety disorder, as described by Dr. Foster, would get anxious very easily, especially when faced with danger. It is also understandable that a person with the disabilities, such as that of the accused, would certainly feel vulnerable when faced with danger. And that's the point, one of the enemy points I make. Some people refuse, point blank, to see in context the true facts. To see a man on his stumps without balance, that's vulnerable, that's not vulnerable from that day, that suffers this slow burn effect, that pervasive effect of vulnerability. The court found that. They want to see Oscar Pistorius running to the bathroom with his gold medal around his neck. That's what they want to see. They don't want to make that conversion from 1.84 to a vulnerable person in the darkness, 3 o'clock in the morning, on his stumps, without balance, suffering from an anxiety disorder. Those are the true facts that's found by this court. We say that the SEA did not reject the findings of the trial court, that the accused was anxious. Rather, the SEA found that although the accused may have been anxious and although he was frightened, a rational person could not have believed that he was entitled to discharge the shots. Now we know a rational person, but we also know that when you stand on stumps and you're not balanced and you suffer from an anxiety disorder, that you're compromised. We also know that. The SEA, the Supreme Court of Appeal, did not reconsider the finding that the accused suffered from an anxiety disorder and that he would certainly feel vulnerable when faced with danger, and those findings remain. The SEA found that although frightened, the accused armed himself, as paragraph 54. The accused could only have been frightened, we say, because of his perception that an intruder had entered his house. Why else was he frightened? Most certainly could not have been frightened of the deceased. We get back to the trial court's findings. The trial court found, quote, the version of the accused was that he fired shots at the toilet door because he thought there was an intruder inside the toilet. The sequence of events, namely the shots, the screams, the shouts for help, the sounds of the cricket bat striking against the toilet door, the calls made by various witnesses to security to report screams and shots are more in line with the version of the accused. I looked at that sequence again. It was perfect. And it's so sad, my lady, and it's not supposed to be before this court. But we cannot escape it that when you look at new investigators and they tell the world that actually the shots were fired last, the cricket bat was first, hit the door open and there was cricket bat marks on the deceased, and you think, why are people doing this when all the experts in this court agreed that first of all the shots and then the bat? You would remember, my lady, there was a crack in the door and it deviated around the hole, which the state expert said clearly, first the shots, then the cricket bat. The defense experts said clearly, first the shots. That's the evidence, irrefutable. You see it. So why would you want to change that around? And once we know that, it started to make sense. Because then we know the second expert, Professor Simon, absolute expert, said, if the shot's there, and you look at the fatality of the wounding, it was not possible for the deceased to have screamed. It could not be. That's confirmed by Dr. Stipp. That's confirmed by Professor Botha. But now you have witnesses who heard a woman screaming, and the court said they're unreliable. They're unreliable for many reasons. But inter alia, they're absolutely against the objective facts, against the experts. They're against a timeline. We could, within 30 seconds, determine when the shots were and when the cricket bat, because we had the times when people say, I've just heard shots. And you could see the time of the call. But somehow, people would refuse to entertain it and say, she was screaming and running away, knowing it's impossible on the objective facts. It remains and is punished forever and ever. You would have heard the evidence of Professor Skoll saying he was in a grocery shop and a woman started screaming, it's a murder, I don't want to be in the same shop. Well, what is that? What is that? Murder of what? That he thought it was an intruder? What is the scene? And that is what is going through, because people, some people refuse to sit back and look at the true facts. Then we say, where the court explained the correct sequence of the event at trial court, the SCA did not reconsider the findings. It was not its duty to do so. And then I've already done it when I referred you to the factual position of the telephone calls, the screaming, and by the way, the direct neighbor saying, well, there's Oscar screaming. That's all gone. They don't want to hear it. It doesn't accord with your perception that you want to follow. 17.6, bottom of page 15, my lady. The trial court found that in its totality, the evidence failed to establish that the accused had direct intention to kill the deceased. I wish I can read it 10 times, but I would not do so, my lady. And then we say, dolus directus, and because dolus directus is, I wanted to kill the deceased. That's rejected on objective facts, not on maybe you did, maybe you did not. We know the facts, we know the timelines, we know the evidence, the expert evidence. We say dolus directus remains rejected by the SCA, both with regard to the deceased and the perceived intruder. The SCA explicitly limited the scope of its inquiry to dolus eventualis in paragraph 24. And I just read where it says, this court cannot interfere, for example, with the factual decision made by the trial court rejecting the state's version that there had been a disagreement between the accused and the deceased that led to the deceased to hide herself in the toilet, to escape from it before being shot. Clear, unequivocal. The Supreme Court of Appeals say, that's not what we're called to do. He summarized that finding. He says, we're not called to reject that. The matter must therefore proceed as was accepted by the state on the basis both that its rejected version cannot be reconsidered and that it has not been shown that the accused has acted with a direct intention to kill the deceased. The state's case before this court therefore revolved primarily on whether the trial court had erred in regard to the issue of dolus eventualis. We say that the basis of the Supreme Court of Appeals finding of murder is dolus eventualis and not dolus directus is also clear from inter alia paragraphs 51 and 55 of the Supreme Court of Appeal judgment and its order. In 51 it says, in these circumstances I have no doubt that in firing the fatal shots the accused must have foreseen, and therefore did foresee whoever was behind the door, might die, but reconciled himself to that event occurring and gambled with that person's life. This constituted dolus eventualis on his part, and the identity of the victim is irrelevant of his guilt. And 55, in the result on count 1, the indictment, the accused ought to have been found guilty of murder on the basis that he had fired a fatal shot with criminal intent in the form of dolus eventualis. There's no space anymore to say the blue jeans were lying left or not right, or the fan was 3 meters to the left or to the right, or whatever, because that was part of the evidence to try and support this attack that it was dolus directus. It's irreconcilable with the finding that at the time of the firing of the shots, that's the remaining finding, that the accused believed that the deceased was in a bedroom and that he was firing shots at an intruder. That would be, to go to that would be a poor and wrong and contentious attempt to reintroduce dolus directus, a defense rejected by this court and not reconsidered by the SCA. The SCA made it clear that that version remains rejected, to use the words. We say in paragraph 17.6.3 The undisturbed finding of the trial court that the accused did not act with direct intent is further supported. I don't know why I'm going there because it is so clear already, but let me go there by the following. If the accused had direct intent to kill the intruder, he would have aimed at chest side and not lower and downwards. The accused was on his stumps, which invariably would have made a downward trajectory lower than that of a person of full height. What am I saying? I'm saying this. Even if you work with the intruder, there's never a finding that they had direct intent to kill the intruder. It was once suggested by the state in the bail application. It is so wrong. Because the finding by the court that he did not aim chest high but lower, that finding remains. Now, if I really want to kill you, direct, I'm not talking about dolus eventualis. I don't stand on my stumps and aim lower. I aim chest high. It's a different story to say, but of course in still firing, you should have foreseen. I understand that you did not mean to directly kill, but you should have foreseen that you could kill the guy, and that was the finding by the SCA. You should have foreseen and you reconciled yourself. You did. You should have foreseen, therefore you did foresee and reconciled yourself. That's the finding. Not that it was a direct intent to kill the intruder. The same principle applies there. 2, we say, if the accused wanted to kill the deceased, he would not have taken all possible steps to save her life. I'm just going to the deceased. Only so that she could expose him as the person who wanted to kill her. The trial court specifically found that the accused's actions in trying to save her life, after he had realized that he had shot her, were supported by the evidence and were not faked. This finding also remains undisturbed by the Supreme Court of Appeal. What we then do, my lady, we have now analyzed the judgment and then go to and we say to you, on those facts, it should not even be a dispute that there are substantial and compelling circumstances. There's a reduced blameworthiness. He stands before you on murder, and we know that what the man wanted to do in his vulnerable state was to protect himself and the deceased. And he incorrectly in law fired 4 shots and is guilty of dolus eventualis murder. But it does not mean that he did not want to protect. It does not mean that he was not scared. It does not mean that he did not think it was an intruder. It does not mean that he was not vulnerable. It does not mean that there were many supporting facts indicative that it was an intruder, the window opening, the door shutting, and so on. They all remain. You cannot ignore that. We say when we look then at the mitigating factors, my lady, may I just ask for a 2-3 minute adjournment? Just a 2-minute adjournment. Just need to clear the throat before I deal with the next item.
Court will adjourn.
Thank you, ladies and gentlemen.
say, well, let's accept that, but let's see what remains. Let's see, having regard to the fact that you're a poor witness, that you vacillated, that you contradict yourself. Let's see what remains, and that is what we're dealing with. What remains? And I think when Professor Scholes gave evidence, Mr. Nell remarked a third version. It's not a third version. All, if you read in context the whole page, all that Professor Scholes was saying, he accepts now, because the judgment is there, that he intentionally shot. He accepts it now. That was not his version, but he does the right thing. You have no choice to accept. We must accept court judgments, and it shows he's moved on. He accepts the blame, and he says, I accept it. That's the judgment against me. What must I do? Kick up dust and fight all the time, or respect the courts? That's all. It's not a third version. It's an acceptance of what was attributed to him by the courts. It's there. With that in mind, I move then to page 18, my lady, to look at what we call the mitigating factors recognized by the trial court in the previous sentencing hearing, undisturbed by the Supreme Court of Appeal, which further contribute to the existence of substantial and compelling circumstances. It would be those circumstances that don't really impact on his moral blameworthiness, but the balance of mitigation. And my understanding of paragraph 9 of Malgas is that you take all factors into account for compelling circumstances. That's already there. It serves a dual role. One, you can also use it for compelling circumstances, but also for mitigation. And these are the factors that we refer to. We say at the previous sentencing, this honourable court found the following circumstances to be mitigation, which mitigating findings remained undisturbed and relevant for purposes of sentencing. 1, it was the personal circumstances of the accused as described by the court, and we give the page references, excuse me. 2, that the accused is a first offender. It's all still valid. 3, that the accused is remorseful. We don't have to argue those findings. 4, the accused lost a person whom he genuinely loved as a result of his unlawful shooting. He must live with that for the rest of his life. What must not be forgotten in the clamour of public punitiveness is that the accused has lost his love relationship at his own hands. In the report by Professor Scholes, and we give the lines, Professor Scholes explained the intense sorrow of the accused and his self-punishment and inescapable guilt. We say that the state has shown compassion for this kind of human tragedy before. We refer to Rudy of Vleisversace. I'm not going to repeat it, just to give you the reference there. We say the accused apologized to the parents of the deceased in court after having made concerted efforts before to do so in private. The conduct of the accused after the incident showed that the accused wanted the deceased to live. All findings by the court there, we give the sentencing reference. But then if I may explain, when you say sentence 1749 and then 3504, what it simply means, there are 2 bundles. The one is the original bundle, the 3504, the trial court bundle, and then there was a reduced bundle for the Supreme Court of Appeal purposes. So we just gave you both page numbers.
Thank you.
It's the same page, just differently paginated. The mental and physical vulnerability of the accused constituted a substantial challenge for the accused. That's a finding by this court in sentence. And we say that the pervasive influence of vulnerability on the thought process and actions of the accused should not be underestimated. The negative impact of media reports on the career prospects and reputation of the accused is beyond dispute. We give that in the court sentencing and also where Professor Scholes refers to that. And then we say in addition to those findings, the following mitigating factors exist. We say the accused has lost all of his assets and his career is gone. The accused can never ever resume his career. The accused has punished himself and will punish himself for the rest of his life far more than any court of law can punish him. I may say here, my lady, it is really, and I say it with absolute understanding, it is understandable within the context of grief and the belief that the shooting was because of anger and not as a result of thinking that it was an intruder, that someone would be calling for punishment and would find it very difficult to forgive. The fact that that was not the court's finding is irrelevant. We understand that. We understand that. But what we also understand is that we can also, or must also, look at the other side. There is a flip side, and that is the accused has paid from the minute he fired the shots and will pay for this for the rest of his life. It's not going away. He lost his future with his chosen loved one. He has paid physically, losing his health. He has paid emotionally. We say he's a shell of the man that he was. We know in the evidence, not only by Professor Scholes, but also the pastor. And the pastor was never challenged on that. He's a broken man. He has paid financially. He's left being dependent on others. He's paid socially. He's judged and vilified by many and verbally attacked. He is paid by the loss of his identity. He's a person filled with self-loathing and loss of self-confidence. He's paying constantly. I am not taking away the grief of the parents and people close to them. They're entitled to it. And it's there, and you must take it into account. We say in paragraph 20.3, the accused cannot bring the deceased back, but he can commit himself to public service in honor of her memory. We say that the accused, and that was the court's finding, the trial court, that the accused's contribution to society has been enormous, as he gave his time and money to various charities and institutions. He has helped change the general public's perception of disabled people and inspired disabled young people particularly as he grew and excelled in his career. And I'm concentrating on the surname, Goodman's doctor. Eva Goodman's doctor from Iceland. It is not going to change the merits, but that finding by the court is ringing so true, where the court found that he has helped change the general public's perception of disabled persons. We've seen an example how enormous it was. What he has done to one family, and it's not the only family, it's just we're privileged to have one person here to share that with the court. 20.4, after his release, the accused again tried to meet with the deceased parents, but was advised by the legal representative that the timing was not appropriate. We understand that it was inappropriate, but he's desperate to do it. And we respect Mr. Steenkamp. He says the time will come, and that's how it will be. But that does not mean that the accused is desperate to reach out. He is. But we respect that. We say that the accused is currently studying a BSc Management with law degree through the London School of Economics, which is an online course. As previously experienced, when he goes back to prison, of course, that will stop because he has not access. There's no access to the computer or internet. He's tried that. We make the submission that the above factors we've already made, but make it again, further constitute substantial and compelling circumstances and also mitigation. Then we deal with the newly introduced aggravation. We say, first, the Supreme Court of Appeal found that the accused had not acted negligently, but with dolus eventualis by discharging 4 shots he had foreseen, and that he had foreseen the possibility of the death of the person in the toilet, and that he had reconciled himself with that consequence. The SCA found that his incorrect appreciation as to who was in the cubicle was not determinative of whether he had the requisite criminal intent, and that he had gambled with the life of the person in the toilet who had nowhere to go. That's aggravation. We respectfully submit, however, that the trial court had to a very large extent already considered the above aggravation at the previous sentencing hearing, as will be demonstrated above. And we first go to the conviction. In convicting the accused, the trial court found we are clearly dealing with error in persona, in that the blow was meant for the person behind the toilet door, who the accused believed was an intruder. The blow struck and killed the person behind the door. The fact that the person behind the door turned out to be the deceased and not an intruder is irrelevant. So that was already considered by the court, so it's not new aggravation. That exact fact was considered by this court. In sentencing, the accused, the trial court found that his negligence was gross negligence that bordered on dolus eventualis. And now we come to mathematical calculations. Border, 1 degree up, 1 degree down, I don't know, my lady. But it's not that this court approached this matter to say, well, this is so removed from dolus eventualis. He was just slightly negligent. It's not the court's finding. The court said, you were grossly negligent to the extent that I agree with the state that your conduct bordered on dolus eventualis. We say the court found, the trial court, that he had used a lethal weapon. That's not new. And fired not 1, but 4 shots. Same finding. The court found that. 3, the court found the toilet was a small cubicle and there was no room for escape for the person behind the door. It's there. It's nothing new. 4, the accused had been trained in the use of the handling of firearms. All those factors had been taken into account at a time in aggravation. We say that the difference between the two findings for purposes of sentence seems to be that the trial court regarded the conduct of the accused to have bordered on dolus eventualis, and the Supreme Court of Appeal found it to be dolus eventualis. Secondly, the Supreme Court of Appeal found that although the accused may have been anxious and although frightened, it was inconceivable that a rational person could have believed that he was entitled to fire at this person with a heavy caliber firearm without taking even the most elementary precaution of firing a warning shot. Therefore, the SCA found that the accused did not entertain an honest and genuine belief that he was acting lawfully when he discharged the shots. We respectfully submit that for purposes of sentence, the fact that the accused belief was not rational and did not meet the criteria for putative private defense does not negate mitigation. We refer to the Ferreira case above again. We submit that the context within which the accused discharged the shots should be considered in view of the following. 1, the accused may have been anxious and was frightened. 2, it was 3 o'clock and dark. A window had been opened in the bathroom, or had opened in the bathroom. 3, the accused was vulnerable because of his disability. And we refer to Ferreira, where the court found that the threat she had feared increasingly pervaded the thinking. Similarly, the accused's vulnerability over a long period of time must have pervaded his thinking. This was also the effect of Professor Derman's evidence. 4, the accused suffered from an anxiety disorder. 5, the accused had a fight as opposed to a flight response. 6, the accused believed that an intruder had entered the house. 7, the accused believed that the deceased was in the bedroom at the time of the shots. Those factors remain with that aggravation. They don't disappear. We furthermore submit that the above factors negate evil intent and motive. Paragraph 26. We do not submit that the above subjective and emotional factors excuse the accused on the merits for purposes of conviction, as it was found that his fear was not rational and therefore not genuine. However, we respectfully submit that his failure to apply a rational thought process does not negate his vulnerability. The pervasive consequence of his vulnerability and his anxiety disorder, which must be considered in the context that the events occurred at 3 o'clock in the morning in darkness. My lady has submitted above and stated in Ferreira that we refer to, a court must, for purposes of sentence, look solely at what an accused believed, irrespective of whether that belief satisfied the requirements of criminal liability in relation to the conviction. He's convicted. As such, his failure to meet a rational test for purposes of a conviction does not negate the accused's reduced moral blameworthiness and the many, many mitigating factors. We respectfully submit, my lady, that the aggravation as a result of the Supreme Court of Appeal findings, as we referred to above, should not be viewed in isolation, but must be considered in the context of his reduced moral blameworthiness, the undisturbed mitigating factors found by the trial court, and the further mitigating factors that arose after sentence, to which we will refer here under. We say it is prudent to also refer to the evidence of Mr. Steenkamp. We understand this unbearable pain associated with the death of his daughter. We respectfully submit that Mr. Steenkamp's pain was compounded by being exposed to an incorrect case presented by the state that the accused had a direct intent to kill the deceased. Clearly, unfortunately, Mr. Steenkamp's pain is exacerbated by the fact that the state scenario caused him to believe that it was an argument and that the accused had a direct intention to kill the deceased. The truth is that the objective evidence proved that this was not the case. The objective evidence overwhelmingly showed that it could not have been the deceased screaming. However, the accused will always be subjected to an incorrect version, which has been so widely disseminated by the press, notwithstanding the court's rejection of this incorrect version. The danger is that a court must be acutely aware, as the trial court was, that the accused may not be punished on account of Mrs. Steenkamp's belief. We say the additional factors now available for this court to consider in further mitigation, meaning those factors, my lady, which did not exist during the previous sentencing hearing. My lady, Professor Scholes was previously appointed by the court as an expert psychologist to report on the state of mind of the accused in terms of the Criminal Procedure Act. For the present hearing, Professor Scholes produced a second report, and we say it was a report of exemplary scientific rigor. The approach taken to his assessment of the accused relied on the most widely used international inventory of psychometric tests currently available. And if I may say, none, not a single one of those tests, were refuted by the state. Not one. The state did not say to him, Professor Scholes, you applied now test A, and those are the results. It's wrong because of that. Not a single word. It was rather, you're biased. Now, my lady, this is a man with respect that did not come to court because he wished to come to court. It was a man that was appointed by the court who did not know the defense from a bar of soap, that was responsible for Exhibit QQQ. I had a relook at that report and I thought, I think that person can assist the court, not me, the court in sentencing, because that person had the privilege under secure circumstances and controlled circumstances and regulated circumstances to analyze the accused. And he spoke of the 2 Oscars. And I thought, I wonder what the position is now. And we asked him, and he was not willing to become involved. He was concerned that it's a dual role that he's taking and he get clearance. And that was the evidence at the start of his evidence to say, we leave you alone. Do what you must do. Look at the person and give us a report back. We want no input in it. And this is the result. Absolutely scientific test. He explains every test in order to come to his findings. And he says every time, the result of that test accords with my clinical observation and with my corroboration. We deal with those tests. We say in paragraph 36.1, that was so important to me. It's my word that I use, but I know that's actually the correct concept, or the word, that the accused is not a malingerer, and that the accused accurately described his current psychological functioning and did not try and create an overly positive or negative impression. So it shows that he found honesty in the accused subjecting himself to the test, honesty in the outcome of the test. It was no process, he could not find any process that the accused tried to manipulate the test. And that's why you have certain tests to catch them out if they do it. 2, he found that his post-traumatic stress disorder has worsened since the previous test in that regard conducted in 2014. 3, his finding is that his general feelings of vulnerability have worsened. 4, and then you can't say, of course, yeah, it's because of your own doing. It's because of your own doing. But what we're then doing, we're going back to, should we convict him or not? That's not the process in sentencing. In sentencing, you say, what is it that you suffer now as a consequence? What are the consequences of your misdeeds? What are those consequences on you? The fact that you cause does not mean that you're not suffering. You still suffer. It means that you get convicted because it's not an excuse, but you still suffer. We say, he finds in paragraph 4, in accordance with the test, that the accused is experiencing an extreme self-consciousness and anxiety about being ridiculed or embarrassed, with which feelings have been exacerbated due to him being vilified in the media and the public. 5, the accused does not have psychopathic tendencies. He's not a psychopath, and that's important. 6, his risk for future violence, serious physical harm, and imminent violence is low. And that will become applicable when you again must reconsider, and I'm so grateful I'm not the court, but when you must reconsider again rehabilitation, deterrence, and to some extent retribution. These factors will come back. We say that Professor Scholes testified that the results of the test were supported by his clinical assessment and collateral information. Professor Scholes also deals with the criminogenic needs, it is the crime-producing factors of the accused, and came to the conclusion that prior to the offence they were absent, but for one factor referred to hereunder. And there he was accused of being biased. If he was biased, why would he annex, keep in his file and refer to the report of Bayi? But Bayi's report, and I will take you there. Bayi's report, if you read it in any context, it says in the beginning period, he was aggressive, violent, he was unhappy. And then he calmed down. And then he calmed down. That's Bayi's report. Not that he was a person that remained aggressive. If that was so, that remained violent, whatever. That's not what she's saying. And I must say, in this context, insofar as Ms. Mashabane's evidence contribute, I was thinking of it last night. If I'm in pain and I want my Voltaren, and for reasons given by Ms. Mashabane, she doesn't want to give it to him because she needs a prescription, and forget about the fact that you don't need a prescription Voltaren. I think I might have kicked the table over and said, I want my Voltaren. He slammed the table with his notebook. What does that make him? It's a man in pain. She's doing what she believes is right. He's insisting to get his medication, what he believes should be available to him. Where does it take us? Does it make him now? I don't know. I don't think it really contributes. I think it rather shows more control than I would have expected. If I may just read the Bayi report, I've handed up to you, I think it was SA1. It says participation in prison, that's that part. Centre management reports that Mr. Pistorius struggled to adapt during his first month of incarceration, as he was aggressive and verbally violent towards officials. However, at the time of the report, he was calm, cooperative, and adapted to the centre. That's the truth. So how is he biased? And he then deals with factors that he thought was important. He did not want to criticize. He says, well, if you force me, let me show you difficulties in his report, but it's neither here nor there. We say that Professor Scholes, as paragraph 38, he distinguishes between the static factors, those that you cannot change, such as prior record of family criminality, and then dynamic factors refer to those factors that can be changed, like the offender's values and attributes. And he says, in order to understand the risk of reoffending, one should focus on the dynamic factors, as the static factors are absent in the case of the accused. And he explained, my Lord, in his evidence that the only dynamic factor which was present in the accused prior to the offence was his values and beliefs regarding to the possession and use of firearms. And he says that's gone. The man does not want to touch a firearm, he does not want a firearm, and in fact when he hears the sound, he reacts in a traumatized way. So that factor is also gone. And that's important because that deals with your risk of reoffending. We say that Professor Scholes came to the conclusion that the criminogenic needs of the accused have been successfully addressed. Page 28, paragraph 41. And would the court give me an indication as to the adjournment?
What's your time?
1:15 now.
Is it 11:15?
It's 1:15. You would see I would most certainly finish by the
It will take about
and not too long.
15 minutes.
Emilia, staan er nu al prijzen in kort, Soleimani? Thank you, ladies and gentlemen.
Yes, Mr. Fu.
Thank you, my lady. It's page 28, my lady, paragraph 41 of the hearing's argument, where Professor Scholes deals with dealt in his evidence with resistance. Now that's important. We raise this because ultimately, when you look at the so-called principles to be applied to sentence, such as deterrence, rehabilitation, and retribution, it is important to look at the risk of reoffending. It's also important to look at the risk of offending. And this is what this paragraph is all about. We say that Professor Scholes dealt with desistance. He describes a desister as opposed to a persister as someone believing that he or she has the ability to make good. Professor Scholes comes to the conclusion that the characteristics for desisters, as found in studies, have a striking resemblance of the accused's views on his criminal act, meaning wanting to make good. Professor Scholes comes to the conclusion that the accused suffers from major depressive disorder with anxious distress, suffers from post-traumatic stress disorder, and we need to understand post-traumatic stress disorder. Post-traumatic stress disorder does not mean I am anxious because of the sentence. It means because of the events I suffer from a post-traumatic stress. It is absolutely connected to the events, not to his fate after the events. And that caused him, what happened there caused him the post-traumatic stress order. That he has elevated levels of anxiety, including symptoms and signs of social phobia, agoraphobia, and panic disorder. Professor Scholes is of the view that the mental health of the accused has deteriorated since 2014, apart from a worsening of his clinical conditions, inter alia the PTSD, the depression, and the anxiety. The accused has become despondent and disinvested, leaving his future in the hands of God. In layman terms, he describes the accused as broken, and in his opinion, he would hospitalize the accused if the accused was his patient. Professor Scholes also states that the accused has strong feelings of unworthiness and self-loathing. The accused has become isolated and fearful of venturing out in public. He has a feeling of disconnectedness. We say that the state tried to discredit Professor Scholes on the basis that he was biased and there's no substance. We say it's significant that the state did not challenge or seek to rebut the veracity of the test done and his clinical observations in that regard. He sought and obtained consent from the Health Council, that's the HPCSA, as he wanted to protect his objectivity. Professor Scholes explained that at the time of his report in 2014, he held the view that there were two Oscars. The one a superstar and tall, and the other a vulnerable, fearful, disabled person of less than 1.5 meters in height without his prosthesis. That was from a professor appointed by the court, not by a defense witness. And that was his report that was not challenged in this court. It was Exhibit QQQ. We all had the right to ask to cross-examine witnesses if we wanted to, and none of us exercised that right. Professor Scholes explained in this court that there is now a third Oscar, a broken man. Professor Scholes' evidence in this regard was supported by the evidence of Pastor Nell, which was not challenged by the state. Pastor Nell testified that he had visited the accused in jail, and I must say quite frequently, and that he observed him to be a broken man. Pastor Nell also testified that the accused was showing strong emotional feelings for the pain caused to the family of the deceased. Pastor Nell also testified that should the court so decide that the accused could be used for charity work in the church, which would entail sport and nutrition training and education for underprivileged children. Pastor Nell explained that the church, the schools, and the accused were excited about the project. That's important. Whatever the court's going to do, it tells us something about the accused. That's the point. He wants to put back into the society, notwithstanding everything that has happened to him. He wants to put back. We say in further pursuance of community upliftment, the accused has also obtained employment as an external consultant at Twin City Development Pty Limited, and that's to manage the Early Childhood Development Project. And that copy is before the court's Exhibit A. You will see it. It's the first 1,000 days in a child's life. That is so crucial. And that is, it's of course to do with underprivileged children and how to give assistance during that period. But the full document is before the court. It is evident from the above that the accused is desirous to contribute to social upliftment as advocated by restorative justice. In addition to the above, we submit, with respect, my lady, that the following factors should be taken into account. He's already served 12 months, and we say that the impact of the 12 months imprisonment on him was harsher than 12 months spent in prison for another offender. We're not getting to a point to ask for privileged treatment. We're stating a cold fact. When you send someone to jail, for whatever the reasons, for whatever the sentence, fact is that a disabled person in jail has a more difficult time. You can say he's not exposed to a cell with many people in, but we know there's also the concept of segregation, where you're on your own and you sit on your own, you get up in the morning on your own, you go to bed on your own. You don't go to the dining room because you can't mix with the other guys because you're a risk. You eat in your cell. You do everything in your cell. You're not out. You get 1 hour a day out in a courtyard, a concrete courtyard. It's punishment. We understand it. And it's something that you must do. But it does not mean that it's easier for him. It's not easier. It's, in fact, if you read anything on segregation, you would see that it's really something that could amount to torture, but we don't say that the department tortured him. That's not what we say. We understand because of his vulnerabilities, disability, because of his high profile, that they had no choice but to do that. That is so. There's no criticism. But factually, that's a consequence of his incarceration. That's what we said in paragraph 56.1, my lady. We talk about solitary confinement as that has been described as a form of torture. We refer you to the United Nations Human Rights Committee, what they say about it. We also refer to Professor Scholz's report, where he explained that psychological stresses such as isolation could be as clinically distressing as physical torture. But we say, my lady, despite the harsh impact of imprisonment on the accused, he has completed all rehabilitative components of his sentence with excellence. The rehabilitative programs that the accused completed were part of his sentence plan as a result of a comprehensive risk and needs assessment, as contained in the sentence plan of the Department of Correctional Services. These programs are designed to correct the offending behavior and enhance the offender's social functioning, preparation for release and reintegration into the community. The programs the accused successfully completed are the following: New Beginnings Program, Restorative Justice Program, Crossroads Program, Anger In, Anger Out Pre-Release Program. Copies of the successful completion of the rehabilitative programs are annexed and marked. It's in the bundle to you. I think it's a waste of time to read it out to you, but you will see when you go to the conclusions every time that it was with excellence, that he motivated other people, that he was doing so well, and that you could see there was an eagerness to do well. That's the accused he wants to put back. He's done wrong and he wants to put back. We say in addition to the programs above, the accused also attended the following individual therapy sessions: its assertiveness, communications, conflict handling, relationships, problem solving, self-development and stigmatization. Insofar as any suggestion is that he does not accept responsibility for what he has done, you will see in the reports that before he was released that there's a column for that, and that the view was expressed that he indeed accepted responsibility for his deeds. That's not the accused saying, it was the department saying that. Therefore, on 5 June 2015, the Correctional Supervision Parole Board approved the accused for release under correctional supervision. On 21 August 2015, being a date after serving 1/6 of the sentence. And I may say up to then. When you receive the sentence in terms of section 2761I, unless you do something wrong, you qualify and you were released after serving 1/6, which would be in a 5-year sentence, 10 months. Didn't happen in the accused place. In his situation, he was told, pack your bags, you're going home, sent all these things home, and then 2 days before there was a complaint, a petition, and the minister said that he did not take the petition into account, but coincidentally on the same date, he then decided that the provision must be looked at again, and a different interpretation was given, and he had to wait for the parole review board and then the parole board again, and he sat an extra 2 months. Now that has not happened to anyone else before, and the difficulty in understanding this, his release was well publicized by the media long before the time, 6-8 weeks before that. Why wait till the last 2 days to do it to a person? That in itself, when you know you're going out, you're sitting there in segregation, you're sitting in a place where you want to get out, you want to do your correctional supervision, and just at the last minute, so to speak, to say, you're going nowhere. You've sent your things home. I know we told you can go. I know the parole board found that you could go, that you qualified. You're staying. You're the first one that's going to be considered to apply a new interpretation. Whether that interpretation is right or wrong is not the question. It is the unfortunate timing of that. It was a long time before that you could look at it. When his release was published 6 weeks before the time, why not look at it then and say, wait, before you get excited, before we tell you to go out, we want to reconsider. You're the first one, you're the guinea pig, you're the first one, we're going to reconsider it. Not in this case, 2 days before. We say that the accused has almost spent 4 months under correctional supervision at the time of the SCA judgment. Thereafter, from December 2015, as part of stringent bail conditions, he agreed to submit himself to even more stringent conditions than the correctional supervision conditions. During this time, he was subjected to countless false alarms. I remember he sent us every time, said, there's a photo, I'm sitting in my house, the alarm went off, I'm not there. There's a problem with that alarm, but it's happened, and it caused him a lot of stress. We say that the decision to broadcast his trial live, it had, of course, its benefits, but let's look at the accused. How did it benefit him? And the resultant media frenzy it has created. It resulted in a trial by public opinion that will continue to haunt the accused long after the conclusion of this criminal process. No other accused has ever had to endure this level of publicity, misinformation, and character assassination premised on a version that he had direct intent to kill the deceased, notwithstanding the fact that that version was correctly rejected by the trial court. Despite the fact that the finding remains that the accused did not want to kill the deceased, or did not even foresee the possibility of her, the deceased death, as opposed to that of a perceived intruder, the accused case is still portrayed in the public domain as an example of gender-based violence. And that hurts him, because he was a person opposed to gender violence his whole life. And now suddenly when there's gender violence and you open a newspaper, his face is there. You see representatives standing for a fight against gender violence. They attend this trial as if he wanted to kill the deceased, as if he had direct. Nowhere along the line would you draw the line and say, enough, enough. This man in his mind had no gender violence intent. It had nothing to do with, it's the same, I drive in my car, I make an accident, happen to be a child or a woman in the other car. How's that gender violence? It's not the consequence, it's the intent. He did not even enter his mind. On the contrary, it was excluded in his mind. He thought she was in the bedroom. Now he's become the face of gender violence. And it's fine to say, protect yourself, don't look. Don't look. It's not possible. It's not possible in this age and era to miss the media. It is not possible to say, I'm never going to open the internet and see my face. I'm never going to open a newspaper. I'm never going to look at placards. I'm never going to watch TV. Constantly it reappears. You see gender violence, domestic violence, you see Oscar Pistorius. We had, not too long ago, threaten with an interdict, to stop a TV channel, to say, how can you do it? How can you use his face? This case has nothing to do with gender violence. But the penny doesn't drop, because some people don't want the penny to drop. It's not what they want. Ignore the court's finding, that's fine. Criticize the court, that's fine. Criticize him, that's fine. We want our perceptions. We say, my lady, that as a result of this sustained campaign of misinformation, the accused's reputation will never recover. And uninformed members of the public, or people who wish to remain uninformed in order to give preference to their own perceptions, have subjected the accused to public abuse and harassment. I told you about the incident. I mean, how silly is it not? He walks in a grocery store and he then gets, women start to scream, she's with a murderer in the shop. I mean, it tells me another woman came to him and said, just excuse her. I apologize for her conduct. But he's subjected to it. He cannot avoid it. We say, my lady, that these factors, in addition to what we've said, also constitute mitigation, but also should be taken into account in relation to compelling circumstances. Now, my lady, when I deal, and this is, in my view, the most important paragraph, is from paragraph 70. It's the reconciled facts between the findings of the trial court and the findings of the Supreme Court of Appeal. If I may fast forward, I'm coming back to it and ask you to go to page 38. Then you will see we deal with the appropriate sentence. And one thing we cannot do is to tell you what a sentence is. We just deal with the principles and then leave it in the hands of the court, what we should do. But, my lady, it is so important that when I deal with this reconciled facts, that we see what we must see. I was right in the beginning when I started to address you, I said there were 4 enemies. And it's that perception, this strong, world-class athlete shooting his girlfriend. And it's time, my lady, it's time for many reasons. For you would have known, you would have seen. But it's time to explain our address to you, to see what we should see. And for that reason, as Mrs. Steenkamp wanted photos, for that reason I want the accused to stand there, and when I address you on that, on his stumps, that we can have an idea of who the second Oscar was. Otherwise it does not help. He would not be seen with that. So I ask permission that he could just come around, my lady, stand there when I point out certain things, that we have reality in this. And it's so important for our case and whatever may follow in this case, my lady. So I ask the court's permission to do that. Thank you. And I'm told he's very embarrassed, but he understands that it's important to do that. He's very, very embarrassed and ashamed, but it's time. You could just take off the legs then. If you can maybe just stand on my side where I can see him and then talk to him. A lady, we talk about the findings and great respect for the Appeal Court of Appeal's finding. I absolutely respect it. But we're dealing with sentence. We have to see rationality now in the context of sentence. And what we have, and these facts can be tested. Just hold on to them. These are the distilled facts that can be tested. Let's look at who is the person. After incorporating the Supreme Court of Appeal's finding that you must sentence today, or Friday, or whatever day, this is the person. It's 3 o'clock in the morning. It's dark. He's on his stumps. That's all common cause. Not on his legs. He's not running around the track. He suffers from an anxiety disorder. We know that the uncontested evidence was that when he was on his stumps, his balance was seriously compromised. And without anything, he would not be able to defend himself. He was anxious. He was frightened. That frightened finding is not gone. And he was suffering from an anxiety disorder. That's not gone. This must all be seen in the context of his disability and the pervasive effect of the disability on his subjective thinking. He proceeded to the entrance of the bathroom because of his excessive fight response and his inability to run away. My lady, all these facts are factual findings, not disturbed, and where the Supreme Court of Appeal made different findings, we included them here. He was armed with a heavy caliber firearm ready to fire. His perception that he and the deceased were in danger was fortified by the following. The open bathroom window, which explained the noise he had heard. So it's not that there was nothing. Of course there was. It's factual findings. The fact that there were ladders outside his house, as his house was being painted at the time, which would have facilitated access to the bathroom. He had heard a slamming of a door and subsequently saw that the toilet door was in fact closed. He believed that the person in the toilet was an intruder and that the deceased was at the time in the bedroom. He fired 4 shots into the toilet door with a downward trajectory, thereby not aiming at chest height. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational and therefore not genuine. And that's where I stop. When I look at him and I think, how rational can it be, my lady? And if he may go back. I see that it's stressful for him if he may go back. And that's the point, and that's the Ferreira's case where I'm at, my lady, where we get to this point. Although he may have been anxious and although frightened, his belief that he was entitled to fire was not rational. For purpose of conviction, I accept that, my lady. I accept that. That's the Supreme Court's appeal finding. That's fine. It's on law principles. But what are we dealing with when we look at that rationality? We're dealing with a person that's not like me. It's not like her, it's not like her. It's a person where I don't want to overplay vulnerability. That's not what I want to do. I don't want to overplay disability, but the time has come that we must just look at different eyes, at least with unbiased eyes. It doesn't mean because he's vulnerable that he can do what he likes. That's not what we're saying. But we're saying we're entering the field of sentencing. Look at that man's conduct. Was his fear rational? No, it was found not to be rational. Meaning that he was entitled to shoot? No. That's why he's convicted of dolus eventualis. But please, let's understand. Let's understand when you combine these factors, you can't look at each one in isolation. Put them in one box and see who's this man that you must sentence. It's not the man running with evil on 2 healthy legs, wanting to protect his girlfriend and running to the bathroom to kill. That's not what it was. It's a compromised person. That's all. We say, my lady, the last finding was In discharging the shots, he foresaw that he could kill the person behind the door, whom he perceived to be an intruder, and he reconciled him with that consequence. He gambled with the life of the person in the cubicle. That's the finding. We accept that. But we say, just look at the he. Factually, his conduct and state of mind can be distinguished in relation to moral blameworthiness, and in the case of dolus eventualis, from the conduct of the person with an able body who was not vulnerable as a result of a severe disability, whose subjective thinking had not been pervaded by his vulnerability, who did not suffer from an anxiety disorder, who during daytime thought an intruder had entered his house, who did not have an excessive flight as opposed to a flight response, who did not believe that his loved one was at the time in the bedroom, and he did not see an open window after hearing a noise resembling that window. Added to the above is the fact that the accused is a broken man who has increased post-traumatic stress, depression, anxiety, and vulnerability. And we don't have to be psychologists to see it, my lady. We don't have to. I don't think, with great respect, that any person could walk up straight after that, going through this process, this judicial process, where you go, where you portray it in public constantly, where you constantly in the media, you go to jail, you come out, it goes to the Supreme Court of Appeal, you come back, you again become subjected to the same process. That's the man, my lady. And of course we can argue it's because of your own doing, but that's on conviction. Let's look at the person and let's see what the system has done to him. I was thinking, my lady, but I'll come back to it. I heard when Mr. Hewitt was in the Supreme Court of Appeal, it was made clear you cannot hide behind your fame. My lord, my lady, he desperately does not want to hide behind fame. He just wants to be treated as a normal, ordinary citizen, not a well-known figure. He does not want fame to make him qualify for something better. He just wants to be treated like someone unknown, someone who has done wrong and must be punished. My lady, when we get to an appropriate sentence in the circumstances, the fact is, and for good reason, that sentencing is preeminently a matter for the discretion of the trial court. We refer to the cases. And we say that makes sense, as it is this court that has not only considered the facts, but experienced the emotions of relevant parties, which are not properly captured in the transcript. You can read that transcript many times. You don't see what a trial court will see. I can read it. I don't see some of the things. You read a sentence, but you don't read the emotion in the sentence. And that is why the rule is so strong that it's for the court, the trial court, to say it, because the court smells it, it sees it, observes it, feels it. It's there. And you form an opinion of who this person is, who's lying, why are they lying, and what emotions they're going through. You form an opinion of the tragic incident, the pain of the family. You all have that. And you put that all together in context. Paper cannot do that. Paper cannot capture that. You must experience, you must be part of that feeling. And we say that is why the rule of law is that sentencing is preeminently a matter for the discretion of the trial court. And it's, I've said it before, I'm so happy it's not me that must impose sentence, because it is so difficult. It is so difficult, but there are fortunately aids to assist, to say these are the rules, these are the factors. We submit, my lady, that the aggravating factors resulting from the finding of the SCA, that's paragraph 76, page 39, do not outweigh the reduced moral blameworthiness of the accused and the other mitigating factors. We've in fact pointed out that you have, as close as what can be to the letter, also consider those factors. It's not that you ignore those factors. We say that this honourable court should, as best as possible, endeavour to strike a balance between the new aggravating factors and the many, many mitigating factors. In so doing, the court should be mindful that in imposing the previous sentence, the trial court has to a large extent already considered the aggravating factors. The question this Honourable Court must decide is what sentence the court would have imposed on a finding of dolus eventualis. That's really the question. That finding must then be adjusted in the light of the accused's reduced moral blameworthiness in relation to the merits, the fact that the accused was in any event sentenced on the basis that his conduct bordered on dolus eventualis, the undisturbed mitigating factors in relation to the conviction, the undisturbed mitigating factors considered at the previous sentence, the new or subsequent mitigating factors available to this court. We say, considering an appropriate sentence, regard must be had to the fact that South Africa is a vibrant constitutional democracy with a progressive system of corrections. And we say that punishment must have a rational purpose. And we refer you to the Mate case, where it says that it makes it clear that punishment must be rational. It's not, we know previously the first choice, the second choice, the last choice was send the man to jail in general. And the courts came out subsequently and said, but that should not be an approach. You should not say the man must go to jail. First look at all options. Find a rational purpose, and sometimes you cannot avoid imprisonment, but then you do it after considering the whole spectrum of the rationality of a sentence. I'm sorry about that, my lady. We say, consequently, our courts, in fashioning a sentence with a rational...
Mr. Roux, just hold on. Okay, you may proceed.
Thank you, my lady. We say in paragraph 81, page 41, my lady, consequently, our court, in fashioning a sentence with a rational purpose that is appropriate to the individual circumstances in the particular case, have shown a predilection for the variety of different sentencing options at their disposal, rather than simply resorting to the traditional approach to impose direct imprisonment as an obvious and first choice of sentence. We say that same sentiment is expressed in Grobler. We refer you to Grobler's case. We refer you to the Sanei case, where the court emphasized that a broad scope of sentencing options must be considered, from which the most appropriate option must be selected. The court in that matter also emphasized that a tendency in the past to regard direct imprisonment in serious cases as the first, last, and only option was not valid anymore in an enlightened society, and that a mental shift was necessary to regard direct imprisonment as a sentence of last resort. The court in Sanei referred with approval to Siebert. It's there, my lady, saying exactly what it's saying. Then there's a Shariva case where the court warned to say a convicted person should not be visited with punishment to the point of being broken. And it goes on to deal about restorative forms of justice and looking at the interest of the society, the victim, and the community. Page 43 at paragraph 85. We respectfully submit that it's clear that punishment is not meant to break the offender, but it's meant to punish the offender and to protect society by providing the opportunity for the offender to be rehabilitated. And we say this was well understood by the trial court. We refer to the sentencing judgment and the record, where the trial court correctly found that excessively severe punishment might break the accused, and that the result might be opposite of what punishment set out to do, which was ultimately to rehabilitate the accused. That one paragraph in the court's previous sentencing, it encapsulates the correct approach to sentence. In paragraph 86, the accused does not fall in the category of offenders who again ought to be removed from society. The accused had already successfully completed all the necessary courses set out as rehabilitative benchmarks by the Department of Correctional Services during his imprisonment. His rehabilitation should not be in dispute. there is no purpose served. And we're dealing just with one aspect. And ultimately, the sentence is in the discretion of this court. There are many factors. We're only dealing with rehabilitation. And we say about that, there is no purpose served in rehabilitating one who has already been successfully rehabilitated. The accused would not have been released on correctional supervision if he posed a danger to society and was not rehabilitated. And it's in fact clear in the reports. The reports are before you, and you can see that. As his rehabilitation has been achieved, deterrence and retribution must be considered to deliberate whether any purpose will be served in that regard through incarceration. We say that the devastating consequences of his actions have clearly deterred the accused. It is clear from his evidence. His incarceration of 12 months served as further individual deterrence. The deterrence remained during his correctional supervision and stringent bail conditions. He cannot sensibly be deterred anymore, and deterrence has with respect reached a point of saturation. We say any general deterrent advantage has already been achieved. If a sentence is now imposed on the basis of further general deterrence, this will merely serve as a veil for retribution. And we refer in this regard to S.S. de Blanche, A Guide to Sentencing in South Africa, the 2nd edition, where he very aptly deals with specifically this effect, and where it's clear that once deterrence has fulfilled its role, that it does not remain as a sentencing option in a particular case. We also respectfully refer to deterrence, that deterrence has already been achieved. Professor Scholes testified that the accused's risk for non-violent reoffending was found to be low. That's also relevant to rehabilitation. Sending the accused back to jail would only serve to break him and to satisfy the consideration of retribution. So we must see if retribution is so important in this case. Our courts, we say in paragraph 92 and page 45, have moved away from retribution as a primary purpose of sentence, making it clear that retribution should yield ground to aspects of prevention and correction. This also seems to be the approach by the Department of Correctional Services, which on a daily basis experiences the negative effects of imprisonment. There was a media statement in 2014, and I'm not going to read it, but what they say, it was the Minister Ndebele says, inter alia, across the world, retribution for imprisonment has not yielded the results of deterring crime. Since retribution is narrowly focused on moral reprobation or outrage against criminal conduct, it fails to adequately reform offending behavior and to repair harm experienced by victims of crime. And it goes on, the full article is also available to you. At page 46, paragraph 93, we say that the shift from retribution to prevention and correction is also reflected in our case law. We refer you to the Matewane case, and we say that that's quite a long time ago that that shift has happened. In paragraph 94, we say that we respectfully submit that the public interest would be rationally served, in this case by considering a sentence that incorporates community service, where the accused gives back to the community whilst not being a burden on the state or taxpayer. This is also consistent with Ubuntu. We again refer to the Ubuntu principle. It's well known to the court. And we say ultimately, my lady, that we tried to reconcile all the facts and all the principles applicable. And then the very difficult task would, of course, remain with this court to decide what's an appropriate sentence. I do not know. I simply do not know. It's for the court's consideration, but we have put before you what we believe are all the distilled facts, where we reconcile the facts of your findings with the findings of the Supreme Court of Appeal, to point out to you that we have not since moved to an evil-minded person wanting to kill his girlfriend. That's not the process. The shift is in fact very limited. Very, very limited. And it's for the court to decide how to approach that limited shift and what to do about it, taking into account this man has served a jail sentence. And then with that in mind, to impose an appropriate sentence. I don't know if there's anything else.
Thank you very much.
Thank you very much.
Yes, Mr. Wu.
And Mr. Court, my lady, we have not had the privilege of seeing the heads before we drafted our heads or before we started arguing, but I will make 11 introductory remarks on Mr. Ruth's argument and then deal with the heads that we have prepared. May I hand up a copy of our heads? But I will deal with the introductory remarks firstly. My lady, as I said when we started, we have successfully appealed the judgment. I will attempt to deal with the findings of the Supreme Court of Appeal unemotionally. But, my lady, the SCA's order deals with a resentencing in terms of the comments made by the SCA in paragraph 3. I will attempt, my lady, to address relevant points. I will not address society. I will not address investigators that wrote the book. I will not address perceptions. I will not address perceptions in the media. Although I will consider dealing with some of the perceptions that Mr. Rue has mentioned. May I start, my lady? That I was rather perplexed when Mr. Rue, and I wrote these words down, when Mr. Rue argued about the lady in a shop that wasn't happy with Mr. Pistorius in the shop. Mr. Rue said the following. She called him a murderer. A murderer of what? Not who. A murderer of what? Someone that he thought was an intruder. As if, my lady, the mere fact that accused thought it was an intruder would detract from the seriousness of murder. A murderer of what, my lady? That what is Riva. That is a murderer of Riva. That's a fact. That's a finding of the SCA. My lady, one can never argue that because there's a finding that the accused thought or knew it wasn't Riva in the toilet cubicle or thought it was an intruder and he fired 4 shots, that's not so serious. That's a less serious murder. Lady, that can never be the argument. Point number 5, my lady. Mr. Rue argued that Mr. Steenkamp's pain was exacerbated by an understanding that this may have been Doris Directus. My lady, I've been astonished by the argument diminishing the father's real grief. I've been astonished. My lady, we saw Mr. Steenkamp. We saw Mr. Steenkamp explaining how he tried to hurt himself just to experience the pain. We saw if we want to talk about a broken man, we saw a broken man in that sitting there giving evidence. That was Mr. Barry Steenkamp. My lady, if it had anything to do with a wrong understanding of the facts, there would have been anger towards the accused by Mr. Steenkamp. My lady, he testified. There was no anger. There was no hatred. It was just a broken father explaining to this court how he grieves for his daughter. It has nothing to do, my lady, with a wrong understanding of the facts. Nothing whatsoever. That's point number 5. Point number 6, my lady. There was argument about a case, vleisversagie. But, my lady, this court and the SCA rejected a defense of putative self-defense. That then puts the versagie matter to rest. It's not relevant, my lady. So, as both the courts rejected that version. Point number 7, my lady. We will deal with it in our heads. We anticipated most of the arguments. Mr. Rue argues the accused accepted the judgment now because it's the court judgment. Because it's the court judgment, what else can he do, is the argument. My lady, but that's very different from accepting my wrongdoing and reconciling myself with the findings of a court. By accepting a court's findings, I have to. The court now convicted me of murder, so I have to accept it. There was no other way out. We approached the Constitutional Court. They didn't help us. Now, before sentence, I just have to accept the court's judgment. My lady, then there was argument that the accused studies will stop in prison. There's just no basis for it. There are hundreds and more people that study in prison. But it's based on what? An argument by senior counsel that his studies will stop. My lady, there's no foundation for that. But, my lady, may I then indicate that if one has a look at the register that was handed in, my lady, that's a register, I think it was SC. One would see, my lady, that the accused requested various things and was allowed various things. In the end, even a TV. He was allowed a TV. Why would he not be allowed a computer to study, my lady? That just cannot be made and cannot be taken into account by this court. Point number 9, my lady. Mr. Roux argued about Sister Mashabana's evidence, that he can well imagine if he had pain and they didn't want to give him medicine, that he may have acted, I don't think acted as the accused did. What I wrote down is that he may have acted. My lady, I have a different argument. I don't expect of any man to enter a room where there are 3 female sisters sitting, banging a table, throwing things on the table, being aggressive. But, my lady, we have a convicted prisoner doing that, convicted of a violent crime. But that's not all, my lady. This isn't the incident in October 2014, December 2014. It's an incident on the 1st of March was something else. It was in February. It's 4 months into his incarceration. My lady, point number 10. You've heard the evidence, my lady, of Mr. Steenkamp. I've listened to Mr. Roux saying, it is now time to see. My lady, there's a request from a father saying, it is now time to see. Is it not time to see what this accused did to Reva Steenkamp? I have a request by the family, my lady. Let us show the world what this accused did. It wasn't an intruder. My lady, you have seen the photographs. I sit with them in front of me. Isn't it time, as Mr. Roux wanted the court to see and the world to see, we now apply, my lady, to let the world see what this accused did with 4 black talon rounds through a door. What this accused did to her head, my lady. That is perhaps time that we also realize that, because, my lady, that would then put us in a position to see what was caused by this accused. Point number 11, my lady. I will then apply, my lady, when I've had a full discussion with the family, for the court to lift the ban on those photographs, as was requested by Mr. Steen. My lady, point number 11. There's reference to S versus Ferreira. I'm convinced, I've seen in the judgment, that the court will look at the facts. S versus Ferreira, my lady, dealing with an abused woman who killed a partner after years and years and years of abuse. That's not what we have in this instance. So, my lady, if I will come back to their heads, may I then deal with our heads of argument? Really, may I refer the court to page 3 of our heads, paragraph 5. We quote the order of the SCA there, my lady. Point number 3, the matter is referred back to the trial court to consider an appropriate sentence afresh in light of the comments made in this judgment. Then, my lady, we will deal with comments made. We deal in paragraph 7, my lady, with the court's finding of personal circumstances during the trial. There's one aspect that I agree. Those personal circumstances that the court found will not have changed significantly. One can find that on page 7 to 13 of the judgment. My lady, but what wasn't quoted was perhaps page 12, line 25, to page 26, line 8 of this court's judgment, where this court said, "There was ever a feeling of unease on my part as I listened to one witness after another, placing what I thought was an overemphasis on the accused's vulnerability. Yes, the accused is vulnerable, but he has excellent coping skills. Thanks to his mother, he rarely saw himself as disabled and, against odds, excelled as a top athlete, became respected worldwide, and even came to compete against able-bodied persons. For some reason, that picture remains obscured in the background. In my judgment, to get to the real picture, the approach would be, we would have to be able to balance the two." My lady, that was echoed, the court's judgment, in paragraph 11 of the SCA's judgment. I refer the court to paragraph 11 of the SCA's judgment. It's a long judgment. I'm not a long portion, but it says how he excelled as an athlete. So the point I want to make is this unease was echoed by the SCA. My lady, what is very important and significant is an aspect that we find perplexing. Dr. Scholes testified that the accused suffered from depression and anxiety. But, my lady, accused counsel put to Sister Mishabane that the accused hoarded medicine that he needed for that condition. It is submitted that the ineluctable inference, my lady, is that either the accused malingered or purposely did not want to get better, or it was a disingenuous version that was put to the witnesses. What was it, my lady? 28 tablets and 14. Isn't it just an indication of this accused's attitude towards the truth? I have to explain everything away, but I cannot stick to the truth. We also know that the tablets were in its packaging. Just before, when she said that, Mr. Roos said, I'll take it up with you later. But it's on record. It's on record that the tablets were still in its packaging. Although Mr. Root tried to stop it, he couldn't. Lady, there's another aspect that's as perplexing. Dr. Scholes viewed that the accused needed hospitalization. His condition was that severe. He reported it to the treating psychiatrist. The treating psychiatrist wasn't called to back that up. No steps have been taken to hospitalize the accused. My lady, this court can only make one inference, and that is that the treating psychiatrist did not agree that his condition was that severe. My lady, we get to Mr. Scholes' report later, but those are aspects that the court must take into account in reading his statement. My lady, at page 5, as far as the seriousness of the crime is concerned, my lady, although the accused was at the time convicted of culpable homicide, this court said, on his own version, the accused knew there was someone behind the door. In this instance, the evidence showed that he thought an intruder was behind the door. Using a lethal weapon, a loaded firearm, the accused fired not one, but 4 shots into the toilet door. My lady, what else can that be than very close? We've argued, my lady, because we couldn't argue differently. When the accused was convicted of culpable homicide, we said it borders on dolus eventualis. Our argument's now different, my lady. Our argument is just that paragraph. If one takes that paragraph, I know there's somebody in the bathroom, I fire 4 shots through that into the toilet door. Why is that not very close to dolus directus? So I argue this. The accused's degree of culpability is very close to dolus directus. That's why the defense argued dolus directus and why one shouldn't even talk about that. There's a realization, my lady, that the accused's culpability is bordering on dolus directus. My lady, the Supreme Court of Appeal, in paragraph 29, may I refer the court to paragraph 29? Mr. Roux referred to the accused did not fire high, the accused fired low. The Supreme Court of Appeal dealt with that. Furthermore, the finding that the accused had not subjectively foreseen that he would kill whoever was behind the door, and that if he intended to do so, he would have aimed higher than he did, conflates the test of what is required to establish dolus directus with assessment of dolus eventualis. The issue was not whether the accused had, as his direct objective, the death of the person behind the door. What was required in considering the presence or otherwise of dolus eventualis was whether he had foreseen the possibility of death of the person behind the door and reconciled himself with that event. My lady, we deal with it a bit later, but let me rather deal with it when we get there. This court, my lady, discussed the accused evidence. I deal with it there. They would fired higher, that's paragraph 3, my lady. The SCA dealt with that, I dealt with that paragraph. This court, my lady, found the following. The accused knew, paragraph 13, my lady, that the toilet was a small cubicle and that there was no room for escape for the person behind the door. Lady, now we have to read the two, paragraph 10 and paragraph 13 together. Paragraph 10, he knew there's somebody behind the door. He knew that such a small cubicle that that person could not escape. He fired using a lethal weapon. The accused fired not 1 but 4 shots. Then we read paragraph 13. It's also significant that the accused had been trained in the handling of firearms. In my view, all that was very aggravating. My lady, if one reads this court's finding, no other court, my lady, those two portions of this court's finding borders, as we say in paragraph 14, my lady, on dolus directus. But, my lady, I don't want to say we support it, but may I refer to what the SCA found and amplified our argument that it's an inescapable conclusion, my lady, that it borders on dolus directus. The SCA, my lady, I refer to paragraph 14 of our heads, to paragraph 49 of the SCA's judgment. On his own version, when he thought there was an intruder in the toilet, the accused armed himself with a heavy caliber firearm loaded with ammunition specifically designed for self-defense, black talon ammunition. We know what it did to the body. Screamed at the intruder to get out of his house and proceeded forward to the bathroom in order to confront whoever might be there. He is a person well trained in the use of firearms and was holding his firearm at the ready in order to shoot. He paused at the entrance to the bathroom and, when he became aware that there was a person in the toilet, he fired 4 shots through the door. My lady, if we read 12, 13, and 14, not 12, it's 10. 10, 13, and 14 together, my lady. He armed himself, walked there, he formed the attention in his room. If I get there, there's somebody there, I'm going to shoot. And he did. My lady, that, what I just said, is a finding of the SCA. He intended to shoot somebody. If he found somebody in the bathroom, he did. Why is that, my lady, not bordering on dolus directus? But, my lady, what's important in paragraph 14 is when the court said, He paused at the entrance to the bathroom, and when he became aware that there was a person in that toilet cubicle, fired 4 shots through the door, and he never offered an acceptable explanation for having done so. Up until today, my lady, not. I don't know what will happen on ITV, but, my lady, in this court, there's no acceptable explanation ever offered. He had the opportunity to do so. He failed. He elected not to, and he hasn't. My lady, as the degree of the accused's intention of culpability, the SCA, my lady, held at paragraph 50. At paragraph 50, my lady, at the time the fatal shots were fired, the possibility of death of the person behind the door was clearly an obvious result. Lady, but one should read the following sentence. And in firing not 1, but 4 shots, such a result become even more likely than obvious, my lady. If you read it, at the time the fatal shots were fired, the possibility of death of the person behind the door was clearly an obvious result. And in firing not 1, but 4 shots, such a result become even more likely. My lady, more likely than obvious. Like borders on dolus directus, not on negligence, my lady. It is far removed from negligence. My lady, I dealt with this, but in paragraph 16, in discussing the defense of putative private defense, the SCA summarized the accused's conduct. And that was the end of it, my lady. Consequently, although frightened, the accused armed himself to shoot if there is someone in the bathroom, and when there was, he did. Lady, that paragraph 54, we now have our paragraph 10, our paragraph 13, our paragraph 14. Read with just this, my lady. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. My lady, it's perhaps pertinent to underline the accused's attitude during the trial. He was a poor witness. He failed to provide any acceptable version for his conduct. At paragraph 17, the SCA remarked, with ample justification, the court found the accused to have been a very poor witness. His version varied substantially. In the light of these contradictions, one really does not know what his explanation is for having fired the fatal shots. My lady, but may I will move on, but may I just pause a moment. If we have an accused, this court found in paragraph 10 and 13, he knew there was somebody, he knew how small it was, he used a lethal gun, he used that specific ammunition. The possibility of death was obvious, more likely than obvious. But this, my lady, consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. My lady, our argument will be and is that that borders on dolus directus. Well, my lady, in paragraph 18, we will discuss later, but we make the point that a finding of remorse in the absence of a credible explanation is implausible, my lady. There's just no remorse for what? For I show remorse because I accept a judgment. My lady, there's a difference. I'm very sorry that Reva's dead. I feel sorry for myself because she's dead. That I understand. But, my lady, why? In the light of these contradictions, one really does not know what his explanation is for having fired the fatal shots. My lady, that in itself excludes remorse by the accused. We don't know. We don't know why he did this. But look what he did. The only plausible explanation, my lady, that remains is that the accused armed himself with the intention to shoot. There was somebody in the bathroom, and then, when there was, he did. He formed this intention in his bedroom, walked all the way to the bathroom, firearm at the ready, and then fired 4 shots through the door, which tore through the flesh of an innocent, defenseless Riva Steenkamp. There's no other finding, if one takes the comments by this court and by the SCA. My lady, if I may deal with the general principles that governing the imposition of an appropriate sentence in terms of the Criminal Law Amendment Act, number 105 of 1997. But, my lady, this has been argued before this court on many occasions. The same thing happens every time. We would say that the court cannot deviate from this. The defense would say the court should deviate from this. But, my lady, for purposes of this argument today, we want to refer the court to the judgments and exactly what was said in the judgment. We submit, my lady, in paragraph 20, that the sentence prescribed for the murder conviction in terms of section 51(2)(a)(1), read with part 2, schedule 2 of the Act, is imprisonment for a period not less than 15 years. I do apologize. I may have a bit older version of the heads than the court, but it's 1 or 2 aspects. I was just shown that there is a proper new one, but that's the one the court has. I will argue on mine, my lady. I'll fix up the differences, but it will be minuscule, very little. My lady, we say that the general principles governing the imposition of a sentence in terms of section 105 of 1997 were enunciated by the court in Malgas. But may I just, before I deal with Malgas, there are 2 aspects I want to emphasize. One, since the minimum sentence legislation was accepted, it's no longer business as usual. And, my lady, the court does not start on a clean slate. Those are the 2 important things, my lady. There is no clean slate looking at the accused to determine what sentence. The clean slate, my lady, starts at 15 years. That's where it starts, my lady. That's what the cases say. We quote Malgas in our heads, now paragraph 24. In what respects was it no longer business as usual? First, a court was not to be given a clear slate on which to inscribe whatever sentence it thought fit. Instead, it was required to approach that question conscious of the fact that the legislature has ordained life imprisonment or a particularly prescribed period of imprisonment as the sentence which should ordinarily be imposed for the commission of the listed crimes in specific circumstances. I'll just read that one paragraph. In short, the legislature aimed at ensuring a severe, standardized and consistent response from the courts to the commission of such crimes unless there were and could be seen to be truly convincing reasons for a different response. Truly convincing reasons for a different response. When considering sentence, the emphasis was to be shifted to the objective gravity of the type of crime and the public's need for effective sanctions against it. That's with the utmost respect, the important passages in Malgas, my lady. We carry on, my lady, in what is now paragraph 25 in our heads, where we quote Malgas. May I refer to B, my lady? Courts are required to approach the imposition of sentence conscious that the legislature had ordained the life imprisonment or period of imprisonment, the sentence that should ordinarily, in the absence of weighty justification, be imposed for the listed crimes in the specified circumstances. Right? We will deal with it, my lady. Malgas was followed, and the principles reintroduced in 2013, 2014, but we get to Machichi and all those cases, my lady. But these are the principles. Indeed, my lady, the specified sentences are not to be departed from lightly and for flimsy reasons. Speculative hypotheses favorable to the offender, undue sympathy, aversion to the imprisoning first offenders, personal doubt as to the efficacy of the policy underlying the legislation are to be excluded. Undue sympathy, my lady, is not an aspect that should be taken into account. The legislature has, however, deliberately left it to the court to decide whether the circumstances of any particular case call for a departure from the prescribed sentence. That's a fact, my lady. While the emphasis has shifted to the objective gravity of the type of crime and the need for effective sanctions against it, this does not mean that all other considerations are to be ignored. And that's not our argument. Our argument is not that we ignore any other considerations. We'll deal with that. It should just be weighty considerations, my lady. Then, my lady, we emphasize paragraph J. In so doing, account must be taken of the fact that the crime of that particular kind has been singled out for severe punishment, and that sentence to be imposed in lieu of the prescribed sentence should be assessed paying due regard to the benchmark which the legislature has provided. My lady, we'll get there. But if the benchmark as a minimum is 15 years, correctional supervision is not close, is not even close to the benchmark. There's no, that kind of sentence, and I say it with the utmost respect, my lady, that lacks the regard. If this court would consider sentencing the accused to correctional supervision, we say that with the utmost respect, but that would neglect the paying of due regard to the benchmark which the legislature has provided. Well, lady, in considering what substantial and compelling circumstances could be, again, in Malgas, my lady, we refer in paragraph 26, as it now reads, the specified sentence were not to be departed from lightly and for flimsy reasons which could not withstand scrutiny, speculative hypotheses favorable to the offender, maudlin sympathy. My lady, in the matter of Khadebe and another, 2013, the Supreme Court of Appeal judgment, in the context of the minimum sentence legislation, the court observed that a period of detention served by an accused prior to sentencing is but one of the factors that should be taken into account in determining whether the effective period of imprisonment to be imposed is justified, whether it's proportionate to the crime committed. My lady, the next sentence reads, such an approach would take into account the conditions affecting the accused in detention and the reason for a prolonged period of detention, and accordingly determining whether substantial and compelling circumstances warrant a lesser sentence. The test is not whether on its own the period of detention constitutes a substantial or compelling circumstance, but whether the effective sentence proposed is proportionate to the crime or crimes committed. Lady, may I just pause? This kind of argument is generally used where somebody's been awaiting trial for a long period before he is convicted and sentenced. That's why the court mentions conditions. The conditions we had here, my lady, is an accused that served a sentence, not a waiting trial, that served a sentence of a year in a wing of a hospital a hospital wing in a prison. And not, my lady, what's also important, not, as Mr. Scott testified, locked up in a small cell for 18 hours of a day. No, my lady. He had to change it. It doesn't happen often that an expert would get on the, would testify and have to change his own report. So, okay, I now concede. Let's make it most days. The evidence by Sister Mashabane is there were 2 cells. There was a wing. He could walk. I'm not saying it's big, my lady, but we have an accused that was in a wing with 1 other prisoner, access to a makeshift gym, and that could walk around. Lady, the conditions that I now describe is not the conditions that the court referred to in Gadebe's matter. That deals with something else, my lady. May I, lady, I just have to follow the new paragraph numbers. May I refer the court to Machichi? Now, Machichi, my lady, is a 2011 judgment, almost 10 years after Malgas. The Supreme Court of Appeal noted that criminality is still on the rise in our country, despite the imposition of minimum sentences, and again stressed the relevance of the legislation of Act 105 of 1997. At paragraph 23, despite certain limited successes, there has been no real let-up in the crime pandemic that engulfs our country. The situation continues to be alarming. It follows that, to borrow from Malgas, it still is no longer business as usual. And yet, one notices all too frequently a willingness on the part of sentencing courts to deviate from the minimum sentence prescribed by the legislature for the flimsiest of reasons. Reasons, as here, that do not survive scrutiny. As Malgas makes plain, our courts have a duty, my lady, despite any personal doubts, to impose the minimum sentence. It's a duty of this court, my lady. May I refer the court then to the next paragraph that we emphasized. The SCA mentioned courts are obliged to impose those sentences unless there are truly convincing reasons for departing from them. My lady, if we deal in paragraph 27, it is paragraph 30. And we say, we respectfully submit that in the exercise of its sentencing discretion, a court should have regard to the public policy and the
That's not my paragraph 27. Are you sure it's 27?
My lady, it's paragraph 29. Wait. No, it's paragraph 30, my lady. I will now, in the lunch break, ensure that mine and the courts are exactly the same.
Yes, thank you.
May I continue for the next
Yes.
2 minutes, my lady, in this fashion, as court leaders. Criminal Law Amendment Act 105 of 1997, as an expression of public policy in a statute, shows the disquiet experienced by the public, represented through the legislature, at the prevalence of certain offences and their effects. My lady, we refer there to the 2003 judgment of Jimenez. The provisions of the Act informs courts of the attitude of society to crimes of a particular nature. One of those crimes, my lady, is murder. In Paragraph 31, my lady. We respectfully submit that in Machichi, the Supreme Court of Appeal, with reference to Malgas, reaffirmed that the starting point for the court that is required is to impose a sentence in terms of Section 105. And it's not a clean slate on which the court is free to inscribe whatever sentence it deems appropriate. But the starting point is a sentence that is prescribed for the specific crime in this legislation, my lady. Paragraph 32. My lady, from paragraph 32, we will deal with, even if the court would find substantial and compelling circumstances, it's perhaps an opportune time, my lady, if the court intended taking the lunch break, to take it now. I can then start with that point soon after the lunch.
We shall take our adjournment.
Emilang, staan er nie op Rising Court toegebaar nie? Thank you, ladies.
Please, of course, my lady, may I refer to paragraph 35?
Paragraph 35.
Yes, indeed.
Yes, of course.
Lady, here we deal with, even if the court would find that substantial and compelling circumstances exist, in the matter of Abrams, the Supreme Court of Appeal held that even where there are substantial and compelling circumstances which justify the imposition of a lesser sentence, the sentences prescribed by the Act create a legislative standard that weighs upon the exercise of the sentencing court's discretion. This entails sentences for the scheduled crimes that are consistently heavier than before. This was in 2002, my lady. Even though the judgment of Abrams is 2002. Even if the court would find compelling substantial circumstances, the clean slate then entails, my lady, that it should be consistently heavier than before, if the court would find that. But I think, and I say it with the utmost respect, paragraph 36 is of importance. In Directive Public Prosecution's North Gauteng versus Tabete 2011 decision, the Supreme Court of Appeal observed that Section 51(5)(a) precludes a sentencing court from wholly suspending a sentence imposed in terms of the Act. Lady, if I refer to Tabete, paragraph 23, it's at page 578 of that specific judgment, it reads, it's true that Section 51(5)(a) of the Act precludes a sentencing court from suspending a sentence imposed in terms of this Act. It follows that the court below erred in having a sentence wholly suspended. Some lady, the sentence that the court would think of in terms of the starting point, which is 15 years, there's no clean slate, we start at 15 years, cannot be wholly suspended, my lady. My lady, we refer to Rosli. Then, my lady, from paragraph 38, we deal with the traditional factors to be taken into account. I will not spend a lot of time on that, my lady. We all know the triad factors in Zin. What I, however, want to just pause at, my lady, is in paragraph 39. At paragraph 39, in the Rabi judgment, and may I quote from paragraph 39. The appellant Judge Appellant Holmes defined the element of mercy as a balanced and humane quality of thought which tempers one's approach when considering the basic factors of letting the punishment fit the criminal as well as the crime and being fair to society. Holmes J.A. pointed out that mercy has nothing in common with maudlin sympathy for the accused. It was, moreover, affirmed that it would be wrong first to arrive at an appropriate sentence by reference to the relevant factors and then to seek to reduce it for mercy's sake. And the way I understand the judgment is if the court would think that a fitting sentence would be 15 years, the court won't think 15 years and now I'll apply mercy. The mercy will be applied in arriving at the sentence, my lady, and not subtracted to what the proper sentence would be. A bit further in that same paragraph, my lady, we refer to Damora. Appellate Division observed in this respect that the question of mercy should be seen primarily in contradistinction to and as a corrective for a tendency towards callous and arbitrary vindictiveness in the sentencing of offenders. But nevertheless, the consideration of mercy should not justify any suspicion of a desire to condone or minimize serious crime. My lady, further, in the same paragraph, paragraph 39, we referred to Rabi, where Rabi summed up the role of mercy. My lady, the court found a judicial officer should not approach punishment in a spirit of anger, because being human, that will make it difficult for him to achieve that delicate balance between the crime, the criminal, and the interests of society, which his task and the object of punishment demand of him. Nor should he strive after severity, nor, on the other hand, surrender to a misplaced pity. Pity will play no role in the sentence, my lady. And we refer in paragraph 40, as we deem it proper, to Samuels as far as mercy is concerned. In paragraph 41, my lady, we discuss the decision of Director of Public Prosecutions KwaZulu-Natal versus P and S versus de Villiers, my lady. In both P and de Villiers decisions, the court observed further that to such element of punishment must be added the quality of mercy as distinct from mere sympathy for the offender. And we defer further to Ter Blanche, my lady. In S versus Swart, in paragraph 42, we go through the case law, my lady, because we want to emphasize that it's not a clean slate. The minimum sentence legislation is applicable. And even if the court would find substantial and compelling circumstances, the decisions directing what then would be a sentence and what would be expected of this court. So, my lady, in paragraph 42, we refer to S versus Swart. We respectfully submit that in Swart, the Supreme Court of Appeal, per Nugent J.A., and a full bench of that court held that in our law, retribution and deterrence are proper purposes of punishment, and they must be accorded due weight in any sentence that is imposed. Each of the elements of punishment is not required to be accorded equal weight, but instead, proper weight must be accorded to each according to the circumstances of the case. Serious crimes will usually require that retribution and deterrence should come to the fore, and that the rehabilitation of the offender will consequently play a relatively smaller role. Lady, and that's our argument. We're dealing with the court convicted this accused, the trial court, of Kabul homicide. And in that judgment said it was a very serious offense. It's now murder, my lady. It's more serious. We've now had the aggravating factors by the SCA. We have that linked to the factors that this court found. We're dealing with a matter that is severe, that's very serious, and we argue that the rehabilitation of the offender will play a relatively smaller role. We've heard Professor Skoll's evidence. His evidence, and he agreed. He admitted that he focused solely on the accused, on what kind of person the accused is. We also know that although he was handed a document highlighted by the defense about aspects that would not fit into his report of the violent actions of the accused, he just ignored that. My lady, the mere fact that that particular report by Dr. Bayi was not given any prominence in the report of Professor Skoll's affects his objectivity, lady, and clearly indicates his bias. My lady, this court dealt with Karg. We've dealt with Karg in our earlier argument. May I refer to paragraph 43, where the finding of Karg was quoted with approval in a more recent Supreme Court of Appeal decision, Director of Public Prosecutions, North Gauteng versus Tabete, where the court added, it's trite that one of the essential ingredients of a balanced sentence is that it must reflect the seriousness of the offense and the natural indignation and outrage of the public. Lady, in paragraph 44, we deal with the fact that it's the duty of this court not to follow public opinion, but to lead public opinion in its sentences. Matlakaza is a matter that we refer to where Harms J.A., as he then was, milady, for the court observed that the object of sentencing is not to satisfy public opinion, but to serve or to lead public opinion or the public interest. The court added, sentencing policy that caters predominantly or exclusively for public opinion is inherently flawed. It remains the court's duty to impose fearlessly an appropriate and fair sentence, even if the sentence does not satisfy the public policy. My lady, in paragraph 45, we refer to Rabi and Strauss, where they note that punishment serves the public interest by discouraging a repetition of the offence by the offender and the perpetration of similar offences by others. Lady, may I pause here again? In Mr. Steenkamp's evidence yesterday, he was at pains to say that he would want people to see what the deceased, what injuries this accused caused to his daughter, to the deceased, so that other people will not do this again. My lady, what this court can do is to, in its sentence, ensure that people would not act as this accused did, arming himself, deciding to shoot an intruder whilst he's still in his bedroom, walking to a bathroom without any danger to him, firing 4 shots in a small cubicle. A sentence by this court should deter people from acting in that way, my lady. My lady, we have focused, and I want to focus on the interest of the victim or the victim's family. My lady, in a murder matter, the victim is deceased. A lot of these cases that would refer to sexual offences, but the principles in those matters apply in this matter as well. My lady, the victims in a matter like this must be the mother, father, and family of the deceased. And they have certain rights that we believe in the last couple of years have come to the fore and should get the attention it deserves, my lady. We say in paragraph 46, it's respectfully submitted that it's important to bear in mind that the traditional aims of punishment have been transformed or affected by the Constitution. It's respectfully submitted that in line with the values enshrined in the Bill of Rights, the interest of victims of crime must be added to the traditional triad factors in considering an appropriate sentence. It's submitted that with the advent of the Constitution, the victim must be afforded a more prominent role in the sentencing process, and indeed, a suitable sentence also needs to be victim-centered. We refer to Machichi, my lady, there is a long quote from Machichi where the court dealt with why it was important to be more victim-centered. We've highlighted some paragraphs where the court discussed the UN Declaration of Basic Principle of Justice for Victims of Crime and Abuse of Power. And may I just focus on the paragraph, the last paragraph, where it reads, the victim is thus afforded a more prominent role in the sentencing process by providing the court with a description of the physical and psychological harm suffered, as also the social and economic effect that the crime had and in future is likely to have. By giving the victim a voice, the court will have an opportunity to truly recognize the wrong done to the individual victim. Maybe we had a victim here that gave evidence that broke down that will never see his daughter. She will never walk again. He will not see her again. He talks to her every day. He looks at photographs of her. He's almost become a recluse. He's done nothing wrong. The deceased has done nothing wrong. This accused murdered her. This is what this court has to sentence. Lady, in paragraph 48, we deal with Machichi and the reasons why the interests of the victims play a more prominent role, my lady. We quote, by accommodating the victim during the sentence process, the court will be better informed before sentencing about the after effects of the crime. After effects, my lady, there's not a day going past that I think of the deceased. Everywhere I go, I'm confronted by what's happened. I will never get over it. That's the evidence that was led. I will never get over it. The court will thus have at its disposal information pertaining to both the accused and the victim, and in that way, hopefully, a more balanced approach to sentencing can be achieved. More balancing than a report by Professor Scholz indicating what is good for the accused. My lady, in the last paragraph, it is thus important that information pertaining not just to the objective gravity of the sentence, of the offence, but also the impact of the crime on the victim be placed before the court. That in turn will contribute to the achievement of the right sense of balance, and in the ultimate analysis will enhance proportionality rather than harshness. My lady, we refer in paragraph 49 to Tabete again, where the court found, where in Tabete it was reaffirmed, my lady, that it admits of no doubt that in the determination of an appropriate sentence, the victim's voice deserves to be heard. After all, it's the victim who bears the real brunt of the offences committed against him or her. My lady, that is where there's a victim, where we can still ask of the victim to tell us. In this particular instance, we can't. But we have victims, my lady. Victims that are suffering, victims that are grieving. My lady, in this particular matter, Tabete, although the court in Tabete indicated that the victim should have a voice, in that particular matter, my lady, the court made it clear that the victim's voice are not decisive. Even if, my lady, and in that particular matter, the victim's forgiven a family member that raped and sexually assaulted her over a period of time, they were still staying in the same house, and the victim said, no, I've forgiven my grandfather. I've forgiven my stepfather. The court said, I understand that you've forgiven that, but that is not decisive. The court will still deal with the gravity of the sentences. Lady, may I, in paragraph 50, interpose to submit that forgiveness does not imply necessarily that the impact of the crime on a victim is any less severe than with a victim who does not forgive the accused. This, for instance, my lady, is borne out in the present matter by the evidence of Barry Steenkamp. In relation to the aspect of forgiveness, it's admitted that it's clear on his evidence that the impact of the death of the deceased remains extremely severe, even though the mother of the deceased has expressed forgiveness in the way that she understands it and to protect herself from getting sick. Needless to say, my lady, Mr. Steenkamp indicated that the accused must nonetheless pay for the crimes committed. Justice must still be properly administered or served despite an expression of forgiveness. Forgiveness, my lady, has more to do with a person forgiving than with a crime. We've clearly heard from Mr. Steenkamp that Mrs. Steenkamp had to forgive for her to carry on. My lady, but we've seen Mr. Steenkamp giving evidence. Although there could be forgiveness, my lady, there is still that need for the courts to do its duty with the utmost respect and to sentence accordance to the crime that was committed. My lady, we say in paragraph 51, and that is a fact. It's rare to find testimony, my lady, showing such devastation that was as experienced by the relatives of the deceased, as given by Steenkamp and Kim Martin. My lady, may I just remind the court of Kim Martin's evidence when she gave evidence in the first matter. The court will remember they're driving to work. They're listening to the radio. They heard over the radio that Oscar Pistorius has killed his girlfriend. Her first thought is, I hope he's cheating on Reva. And then, lady, she said, everything changed. Her whole life changed. She explained how they drove back to her mother's house. How they got to her mother's house, her mother was crying, she knew there was something wrong. How they had to go to the funeral. My lady, and the evidence that struck me by Mr. Steenkamp is when I asked him what happened on the day. No parent deserves, my lady, to get a phone call, to get back home, to drive and think, what's going on? Is it one of the animals that died, or was it? But I heard Reva's voice. And my lady, when he said, it was just chaos. It was chaos. I just wanted to see my brother. My lady, that is what the courts are there for, with the utmost respect and as a duty, to protect society from this happening. And when it happens, my lady, to show that the courts will never be lenient on any crime that caused that grief to any victim, my lady. My lady, we refer in paragraph 52 to Isaac's matter, where Judge Davis, in 2002, my lady, expressly held that there are 4 central factors in imposing a sentence, being the offender, the offense, the community, and the victim. We quote Judge Davis, there's an unfortunate tendency for presiding officers to invoke the well-known triad of circumstances as set out initially in S versus Zinn, almost as a ritual incantation to a query as to the justification for sentence. The dictum of Room J.A., as he then was in Zinn's case, serves to set out the elements which require careful consideration before punishment is imposed. Indeed, this so-called triad itself reflects a somewhat outmoded view of punishment, in that it omits to take account of the specific interests of the victim, which might well be different from those of society. Lady, we have in the past argued that the victim's rights should be discussed as part of the interests of society, but it cannot still be viewed as such, my lady. In this particular matter, society at large would sit back and would experience, as Judge Leach put it, a human tragedy of Shakespearean proportions. But, my lady, the court heard the victims. The court seen the grief of the victims. And their rights should get the same weight as all the other 3 factors. My lady, when we deal with remorse and rehabilitation in paragraph 53, and we're back at Machichi, the appeal court described the essential nature of remorse, the Supreme Court of Appeal, my lady, described the essential nature of remorse and what the factors are which are indicative of genuine remorse. Lady, and there we quote, there's a chasm between regret and remorse. Many accused persons might well have regret their conduct, but that does not without more translate to genuine remorse. Remorse is a gnawing pain of conscience for the plight of another. Thus, genuine contrition can only come from appreciation and acknowledgement of the extent of one's error, whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question. My lady, the court dealt with remorse in the judgment in sentence earlier. The court referred to the accused's conduct shortly after the deceased was killed. My lady, I argued then, and I do it with respect now, that any person having just killed someone would feel remorseful, would not have wanted to do it, would feel sorry. Having killed Riva, I'm sure he thought, why did I do it? She's not there anymore. But my lady, real remorse would have been the accused taking the court into its confidence, telling the court why I fired those shots, why I acted in the way I did, so that the court can accept that, my lady. We don't have that. We had the opportunity, but we don't have that. My lady, I have to quote this, I have to just follow this whole quote. It's to the surrounding actions of the accused, rather than what he says in court, that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere, and the accused must take the court fully into his or her confidence. We don't have that, my lady. We have an accused whose version was rejected. We have an accused, my lady, who in May 2015, in the report by Bayi, thought that he was not even a criminal. He did nothing wrong. Then something happened, and there's no way out. The ACA is pronounced on the crime. We could not approach the Constitutional Court. That was refused. I accept the verdict. But, my lady, acceptance of the verdict, with the utmost respect, my lady, is not. The penitence must be sincere, and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that the accused person is genuinely remorseful, it needs to have a proper appreciation of, inter alia, what motivated the accused to commit the deed, what has since provoked his or her change of heart, and whether he or she does indeed have a true appreciation of the consequences of those actions. Now, the first question, what motivated him, we don't know. The court made a finding, but not on what he said, on the circumstance. The court rejected his evidence. So did the SCA. What has since provoked his or her change of heart? My lady, I don't think it was a change of heart, but if we have to take into account what Professor Scholz testified, it must be the SCA decision, and it's now there. I have to. I just have to. There's no other way out. But that, my lady, that is not remorse. My lady, we also refer to Nkunkuma and others, my lady, where the description of genuine remorse and the factors to be considered was endorsed by the same court, my lady. In S versus Van Rensburg, my lady, at paragraph 55, a very recent decision, 2015-1, the court observed, the first step to a rehabilitation is to acknowledge a wrong committed, and that if the accused does not admit wrongdoing, even after conviction, there is no sign of remorse. There's a difference, my lady, with the utmost respect. I've caused her death, and I've murdered her. I've caused her death is not the same as I've murdered her. For remorse, one needs, I've murdered her. This is why I'm sorry. This is why I did it. Without that, my lady, there can be no remorse with the utmost respect. In paragraph 56, my lady, we submit that in the absence of true remorse, that the absence of true remorse is indicative of an accused having no insight into his or her conduct of committing the crime, and thus suggests that the chances of or prospects of rehabilitation are remote. For if there is no acknowledgement by the accused of wrongdoing, that is, of actually having committed the crime in question, What is there in the mind of the accused that he would need to be rehabilitated from? Lady, and with utmost respect, my lady, what is important here is we have an accused that whose evidence was rejected. We'll come to the SCA's view on his credibility. We have an accused, my lady, that in May 2015, in talking to the psychologist at the prison, had no insight, none whatsoever. Now something happened, but he hasn't taken the court into his confidence. We don't know what. It's just to prepare himself for sentence. He has to. I have to say that I now accept the sentence because the court will re-sentence me. But, my lady, the court has heard nothing. In fact, my lady, what the court has heard is that an accused elected to give an interview to the TV, but not take this court into its confidence. That's disrespectful to the courts, that's disrespectful to the victims of this crime, it's disrespectful to the deceased. My lady, in Janti, the court pertinently held, seeds of rehabilitation can, in a manner of speaking, germinate only if the convicted person himself has, first and foremost, expressed contrition for his criminal wrongdoing, thereby accepting the gravity of the criminal act of which he has been convicted, and commits to return to the path of rectitude. Without expression of contrition, any hope of rehabilitation becomes illusory and thus an unrealistic expectation, and not merely a speculative hypothesis. We say in paragraph 57, my lady, it's respectfully submitted that applying these principles to the present matter, the accused cannot be said to have true remorse and consequently be ripe for rehabilitation, where the Supreme Court of Appeal, in this case on appeal, affirmed that the accused was a very poor witness whose evidence was so contradictory and vacillating and untruthful as to his state of mind when he fired his weapon, killing the deceased, and that therefore, and these are the important findings, my lady, one really does not know what his explanation is for having fired the fatal shots. One does just not know his true explanation for firing the weapon. And he never offered an acceptable explanation for having done so. We respectfully submit, my lady, that in the present matter we are still in the dark as to why the accused fired the fatal shots. Coming from him, my lady, we don't know, as the accused has chosen not to take the court into its confidence. This, with respect, is a significant aggravating factor and nullifies the accused's purported remorse and contrition, which Dr. Jonathan Skolt testified that he has. The aspect is compounded by the fact that Dr. Skolt still referred to the accused as having taken the life of the deceased without intending to do so. And he said that. And, my lady, we also refer to Ms. Bai's report, where she wrote, he fails to identify himself as having committed a crime, as his intentions were to protect the victim. My lady, may I just pause? If the accused informed this court what happened between May 2015 and now, why he changed his mind of not having committed a crime and accepting that he murdered the deceased, that would have been something to argue on by the defense, but we just don't have it. We have the fact that he fails to identify himself as having committed a crime while serving a sentence, my lady. And he still hasn't done so, not by himself. We submit, my lady, that in S versus Martin, although the accused pleaded guilty in that particular matter to counts of murder and attempted murder, and he never testified, the court, as per Fleming, Deputy Judge President at the time, held as follows, my lady. To determine sentence, particularly for a more serious crime, there's not a more important question than, why did you do it? It's hardly excusable to ask an accused how many children he has and to omit the crucial, why did you do it? Only in an exceptional case will the answer to that question not be dominant in getting to understand the influences on the accused and generally to discover the true degree of moral reprehensibility. With no known answer to that question, the accused is at risk of appearing to have acted without reason and to deserve the harshness which accompanies wanton criminality, which is executed without anything which reduces moral reprehensibility. An accused assumes some risk by failing to testify, in that there is then often a preclusion of opportunity to give an answer to that crucial question. Counsel's speculation without a factual basis is not an equivalent. Milady, and that is exactly what we have. We will have Mr. Roux that will give the court lots of reasons why that happened, of being vulnerable, walking up and down, being scared, why he did it. My lady, but it's now done. The judgment was changed into one of murder, Doris Charles. It's now up to the accused to take this court into his confidence and to explain to this court. He hasn't done so, my lady. He hasn't done so. But the court knows that he has given a version. Whilst awaiting this procedure, whilst awaiting sentence, has given a television interview explaining himself, talking about that night. We at paragraph 60, my lady, we say that rehabilitation may also be inadequate when the other sentencing considerations are assimilated into the scales. In such a situation, rehabilitation will not be considered of overriding importance. My lady, and that's, this principle is important. And Lister, my lady, that we referred to here, about prison and about sentence, and about all the arguments we've had by Dr. Scholes about the conditions, is of utmost importance. In Lister, my lady, the court said, prison, one knows, is not a congenial place, and the conditions may well be less than ideal for psychotherapy. But then, a prison is primarily an institution of punishment, not cure. As the court of quo was at pains to point out, the approach of a sentencing officer is not the same as that of a psychiatrist. The sentencing officer takes account of all the recognized aims of sentencing, including retribution. The psychiatrist is concerned with diagnosis in rehabilitation. To focus on the well-being of the accused at the expense of other aims of sentencing, such as the interests of the community, is to distort the process and to produce, in all likelihood, a warped sentence. My lady, having known that we would refer to Lister, I asked Professor Scholes on 2 occasions, "You've only looked at the accused, nothing else." And he said yes. And my lady, that's what the court said in Lister. The court has a different duty. My lady, the principle enunciated in Lister was endorsed by the Supreme Court of Appeal in a recent decision of S versus SD. My lady, that's a 2015-2 matter, my lady, by Justice Brandt, where the matter was articulated as follows. It must be remembered, however, that medical experts, by nature of their profession, have a different perspective. Their purpose is to diagnose, to heal, and to rehabilitate their patients. As a rule, they do not have to consider their perspective, which the courts are obliged to keep in view. Our sentencing function is quite different. Apart from rehabilitation, we also need to have regard to the other interests, such as prevention and retribution. To focus exclusively on the well-being of the accused person is likely to result in a distorted and warped sentence. Lady, may I, whilst I referred to Lister, I had to pause and to indicate to the court that whilst the accused was in prison, he was allowed visits and access to his private doctor. He was allowed visits and access to his private psychologist. He was allowed visits by his pastor, by family. Dr. Scholz indicated that he received counseling by Dr. Hartzenberg whilst being in custody. My lady, in paragraph 62, we refer to a comment by Blanche in his treatise on sentencing. May I refer to S versus Rowe and another? It's a 2010 decision, my lady. The majority of the Supreme Court of Appeal, per Majid, acting Judge Appellant as he then was, my lady, citing with approval, Lister found that to elevate the personal circumstances of the accused above that of society in general and the victims in particular would not serve the well-established aims of sentencing, including deterrence and retribution. And in S versus Vilakazi, my lady, in 2009, Nugent J.A., for a full bench of the SCA, pointed out that in cases of serious crime, the personal circumstances of the offender by themselves will necessarily recede into the background. My lady, we're dealing with a very, very serious offence. I'm not saying that the personal circumstances of the accused should not be taken into account. But in this particular instance, my lady, it recedes into the background. In the SCA decision of Combrink, my lady, the appeal court was critical of the court of quo's approach of focusing exclusively on the mitigating factors instead of balancing them with the aggravating factors, and in particular of overstating the personal circumstances of the accused, whilst virtually ignoring the personal circumstances of the deceased and the gravity of the offence. That is such an important judgment, my lady. Whilst virtually ignoring the personal circumstances of the deceased and the gravity of the offence. My lady, in what I've heard in the evidence that was laid on behalf of the defence, the deceased in this matter disappeared. Lady, we've done a trial. We were here for many a day. One get the feeling that the personal circumstances of a deceased just disappears. The court said in this particular matter, my lady, in Combrink, that the court should take into account who she was, what dreams she had, because, my lady, she had no contributory factor in her death. It was all the accused murdered her. She wanted to go back. She wanted to look after her father and mother. She wanted to be a model. She was on TV. Those things, my lady, is just as important as the personal circumstances of the accused, the personal circumstances of the deceased. The Court of Appeal added, my lady, that the loss of life would self-evidently have had a negative impact on the family of the deceased, and that life was the most valuable asset of the deceased, which had been taken away from him. May I pause? Life was the most valuable asset of the deceased. It does not matter if the accused thought she was an intruder. Is the intruder's life not important? Did he not think of an intruder's life? He didn't. He intentionally in his view, on the argument of the defense, intentionally killed an intruder. That's not important. As long as we can just cover in our argument that he never thought he was killing Riva, then we're happy. But you can't do that, lady. What happened is, the consequence of his actions, the consequence of his intention, is that the deceased lost the most valuable asset she ever had, this her life. She can never walk in court, my lady. The Court of Appeal affirmed that murder is a very serious offence and that the resort by the accused to his firearm and the killing of the deceased was gratuitous. My lady, I had to look up the meaning of gratuitous. And the best way of explaining it for me is the use of his firearm in the killing of the deceased was excessive and unnecessary. It's exactly what happened here, my lady. I cannot think of a more excessive use of a firearm. By arming yourself in your bedroom, walking to the bathroom, gun at the ready, and thinking that if there's somebody in the bathroom, I'm going to shoot, and when there was, he did. It was totally excessive. Firing 4 shots through that door, my lady, that tore up the body of the deceased, was in fact gratuitous. My lady, in the matter that Mr. Roux referred to, Hewitt versus the state, we don't have it with us, my lady, but if you would want a copy of it, we'll make it available immediately through your clerk, if you would want to have that particular judgment. Scrupulous care must be taken not to overemphasize the appellant's personal circumstances without balancing those considerations properly against the very serious natures of the crimes committed, the aggravating circumstances, and the consequences for the victims and the interests of society. Lady, this is a well-published matter of a tennis coach that is well advanced in years, that committed the crime lots of years ago and was sentenced to direct imprisonment. Why should this accused escape direct imprisonment? My lady, we deal with anticipation of what the defense might have argued. We deal with the factor of dolus eventualis and dolus indeterminatus in the determination of an appropriate sentence. Firstly, my lady, we submit that dolus eventualis is not per se a mitigating factor. Rabi and Strauss note with reference to Dladla and andere that the correct approach is whether in a particular case, in the light of all the surrounding circumstances, the absence of direct intent can be regarded as mitigating. My lady, we referred in paragraph 66. It's perhaps more important to refer to Dladla, in where Dladla endorsed the finding of Minis, affirmed that what is required in determining whether dolus eventualis can be a mitigating factor is a gradation of the degree of foreseeability. This is by reason of the fact that dolus eventualis is an elastic concept. On the one extreme, it can border on negligence, especially culpa lata, and on the other side, on dolus directus. Janssen J.A. added that it's not the ex post facto objectively determined foreseeability that is involved in the gradation inquiry, but the subjective contemplation of the doer in the commission of the act, whether he or she regarded the possibility as a faint or strong possibility. My lady, we don't know. We really don't know. He has not given us an acceptable version. What we do know, however, is the accused testified that he did not want to shoot a warning shot into the shower because he was worried that the bullet might ricochet back and hit him. But he fired 4 shots. through a door into a small cubicle. My lady, and then I have to refer to the SCA judgment. At paragraph 50 of the SCA judgment, as a matter of common sense, at the time of the fatal shots were fired, the possibility of death of the person behind the door was clearly an obvious result. And in firing not one, but 4 shots, such a result became even more likely. But that is exactly what the accused did. A court blessed with the wisdom of hindsight should always be cautious of determining that because an accused ought to have foreseen a consequence, he or she must have done so. But in the present case, that inference is irresistible. A person is far more likely to foresee the possibility of death occurring where the weapon used is a lethal firearm, as in the present case, than, say, a pellet gun, unlikely to do serious harm. Indeed, in this court, counsel for the accused, while not conceding that the trial court had erred when it concluded that the accused had not subjectively foreseen the possibility of the death of the person in the toilet, was unable to actively support that finding. In the light of the nature of the firearm and the ammunition used and the extremely limited space into which the shots were fired, his dividends is understandable. My lady, but having quoted the Supreme Court of Appeal, I have to refer back to Minis. Minis, and that's why I quoted it. Paragraph 66, Janssen J.A. said, added to this, that it's not the ex post facto objectively determined foreseeability that's involved in the gradation inquiry, but the subjective contemplation of the doer in the commission of the act, whether he or she regarded the possibility as a faint or strong possibility. We, in paragraph 68, my lady, respectfully submit that the degree of dolus eventualis, which the accused had in the present matter, bordered on dolus directus and not on negligence. Then, my lady, we deal with dolus indeterminatus. We respectfully submit, my lady, that in a present matter, the Supreme Court of Appeal held that although a perpetrator's intention to kill must relate to the person killed, this does not mean that the perpetrator must know or appreciate the identity of the victim. The court explained, a person who causes a bomb to explode in a crowded place will probably be ignorant of the identity of his or her victims, but will nevertheless have the intention to kill those who might die in the resultant explosion. Reverting to the lexicon of a lawyer, this is known as intent in the form of so-called dolus indeterminatus, the killing of an indeterminate person. But, my lady, if there was a bomb, if somebody placed a bomb and a bomb exploded and killed 50 people, you'll be convicted of 50 counts of murder, not of indeterminate people, but of the identity of those people, because that's what he did. Although he had dolus indeterminatus as far as that was concerned, he did not care who he is killing. He killed that particular person. That's what happened here. Although Mr. Rook can argue that he thought there was an intruder, and that must in some way be a mitigating factor. How, I don't know. But the mere fact that he thought there was an intruder should be a mitigating factor, I don't see. But that doesn't make sense. But that does not necessarily mean that this accused is not guilty of the murder of Reva. He's guilty of the murder of Reva. He killed her. My lady, the court in the SCA correctly held that dolus indeterminatus is not a form of intention apart from dolus directus or dolus eventualis. It's merely a label, meaning that the perpetrator's intention is directed at a person or persons of unknown identity. A perpetrator can therefore act with dolus indeterminatus simultaneously with dolus eventualis. The trial court referred to Snyman, and we deal with that in paragraph 71, my lady. 72, my lady. When we drafted that, we had to anticipate what the arguments would be, so it reads, It is thus submitted that if the argument were to be advanced that the accused did not appreciate at the critical moment that it was Reeva Steenkamp who he fired the fatal shots at, but an indeterminate person, and that consequently ought to be regarded as a mitigating factor on the question of what the accused foresaw, our contention is with respect that such factor does not detract from the fact that dolus eventualis, in this case, borders on dolus directus, given the Supreme Court of Appeal finding in paragraph 50, and there's still no acceptable explanation for why the accused fired the fatal shot. More than one, 4 shots. It's accordingly respectfully submitted that any argument pertaining to mistaken identity of the victim cannot constitute a mitigating feature. The fact remains that the person was intentionally killed by the deceased for reasons that only the accused knows, but which the accused has not given an acceptable account of. As the Supreme Court of Appeal found, the accused no doubt in firing the fatal shots foresaw that whoever was behind the toilet door might die, but reconciled himself to that event occurring and gambled with the person's life. This constituted dolus eventualis on his part, and the identity of the victim is irrelevant to his guilt, my lady, and irrelevant to sentence. We deal with the nature and gravity of the offences, my lady. The deceased was killed. She's dead. She will never realize her dreams. Her greatest asset, namely her life, was taken away by the accused. The deceased did not contribute to her death. She innocently, on the court's finding, went to the toilet in the early morning hours. The deceased died a horrific death. We respectfully submit that the court, in fact, accepted the evidence of, as he then was, Captain Mangena, that she was standing in the door, in front of the door, facing the deceased. That was his evidence, my lady. The court accepted his evidence. So his evidence is, when the accused fired the shots, Reeva was standing in front of the door, facing him, where the first shot hit her in the hip, and then the other shots were fired. The court should, with respect, take into account that the deceased had nowhere to go, and that one after the other bullets ripped through her flesh. The accused had been convicted of murder, my lady. He intentionally killed the deceased. However one want to explain it, the finding is the accused, with intent, killed the deceased. Although he may have thought he was an intruder, the finding is he's guilty of the murder of Reeva. This court, my lady, in Tatane's matter, found that taking the life of a fellow human being is always a serious offence which lead to outrage and demands heavy punishment. We refer to Makwanyane and another Constitutional Court decision where the court held the need for strong deterrent to violent crime is an end to the validity of which is the need for strong deterrent to violent crime is an end, the validity of which is not open to question. The state is clearly entitled, indeed obliged, to take action to protect human life against a violation by others. In all societies, there are laws which regulate the behavior of people and which authorize the imposition of civil and criminal sanctions on those who act unlawfully. This is necessary for the preservation and protection of society. Without law, society cannot exist. Without law, individuals, society have no rights. The level of violent crime in our country has reached alarming proportions. It poses a threat to the transition to democracy and the creation of development opportunities for all, which are primary goals of the Constitution. The high level of violent crime is a matter of common knowledge. Those who engage in violent crime should be met with the full rigor of the law. My lady, may I pause here and just argue, as Mr. Roux did. The accused thought there was an intruder in the bathroom, in the toilet cubicle. He walked there and fired 4 shots. that cannot be a mitigating factor. I just cannot see how the fact that he did not think it was Reva, but intruder can ever be a mitigating factor, except if you say the life of intruder is less important than the life of Reva. If you say that, but I don't think Mr. Roux will ever say it. But that is the only way one can argue that it's a mitigating factor. Without that, we can never argue that it's a mitigating factor. She is, after all, she is the one that was shot. Well, lady, it's almost with respect odious to repeat that murder remains the most reprehensible crime that can be committed because of flagrant disregard it entails for the sanctity of human life. There's moreover an outcry from society against such crimes. Society demands that robust sentences must be imposed. My lady, before I go to the conclusion, I feel duty-bound to refer the court to a specific aspect in the judgment by the Constitutional Court. At 451, my lady, page 451, paragraph 56.
Judgment by the
That is by Justice Leach in
the Supreme Court of Appeal. I thought you said the Constitutional Court.
No, Supreme Court of Appeal. If I did, I apologize. I'm sure I did, but I apologize. Paragraph 56, my lady, where the court referred the matter back for sentence. That's perhaps why I refer to the Constitutional Court, my lady. Quite properly, particularly in the light of the Constitutional Court judgments in Nabulisa and Bogarts, as the matter must be sent back to the trial court for sentence to be imposed afresh. In doing so, obviously, whatever punishment has already been served by the accused in respect of the incorrect conviction of culpable homicide will be taken into account. That the court has said. And I feel duty-bound to indicate that that was a finding. My lady, in our conclusion, we argue that the minimum sentence of 15 years ought to be imposed. If, however, my lady, this court will find substantial and compelling circumstances that the court would feel justify a lesser sentence, we argue for long-term imprisonment that should be imposed. My lady, I've argued that I think that 15 years imprisonment ought to be imposed as a minimum. I don't think the life of Reva Steenkamp was a minimum, my lady. The matter is so serious that I've taken everything into account that have been argued. And that still remains to 15 years, my lady. My lady, now I have to deal with one specific aspect, and that is the aspect that I touched on in terms of the photographs. My lady, this court made a finding that the photographs of the deceased and certain of the photographs should not be viewed. Mr. Roos indicated that it's time for him to do certain things. The witness at the state court said it's time for the world to see those photographs. So we apply, my lady, for the lifting of that order, and so that those photographs can, for once and for all, be viewed by everyone. And, my lady, we will not show as the photographs that Dr. Simon dealt with. Those are not the ones, my lady. But our application is, in particular, Exhibit E. And it's photograph numbers 135, 136, 137, 138, 139, 140. I have, my lady, in the break, had a consultation again with the parents. I have shown them the photographs, and they asked me to bring this application seriously, bring a serious application for this order. the order that we seek, my lady, is that the court will allow those photographs to be made available publicly. My lady, as I indicated, I've not had the heads of argument of the accused before I started arguing. Will the court allow me just to page through them and where I made notes to deal with one or two aspects, my lady, of the heads of argument of the accused?
So you say you need more time.
No. May I stand here and page through them? So I'll just be paging. I've made notes and I'll decide on what I would address. My lady, at paragraph 9 of the heads by the accused, it's not our argument that the SCA dealt with factual findings, but the SCA in fact said that using the factual findings of this court, it's as good a position to make inferences from the proven facts as he did. And that, my lady, are the inferences that we have referred to in our heads. So it's not a new set of facts, my lady, but inferences from proven facts. My lady, I have a note in, whilst Mr. Rue was arguing, I made a note. May I just but anyway, where Mr. Rue at paragraph 13.
1.3.
1.3, my lady, yes. Where Mr. Rue refers to the SCA judgment in paragraph 30. I made a note that one should just read that paragraph further. The paragraph reads, my lady, I've emphasized that the trial court's consideration of Dolly's event trial is centered upon whether the accused knew that the person in the toilet cubicle was Reva, and its conclusion that Dolly's event had not been proved was premised upon acceptance that as he had thought Reva was in the bedroom, he did not foresee that she was the person in the toilet. Simply put, the finding was that the accused did not realize that it was Reva in the toilet. He did not foresee that the action of shooting could cause a death and could not be held guilty of a murder. But 31, this finding goes to the heart of it, and then he deals with dolus indeterminatus. So all it means, my lady, is that her identity, the identity of the deceased in this matter, is not a crucial aspect. And that's what the court dealt with there. My lady, this is a very unprofessional way of dealing with heads, but that's the only time I have available. In paging it, I made some notes. Uh, 17.2.1. The ACA did not consider the trial court's finding that at the time of the shooting, the accused believed that the person in the toilet was an intruder and that the deceased was in the bedroom. My lady, my comment is, with the utmost respect, it does not make a difference. It does not detract from the seriousness of the crime. The person that's dead is Reva Steenkamp. We have dealt with 17.2.4, my lady, the Ferreira matter. That's distinguishable on the facts. So totally different facts of an abusive relationship where a partner had no way out but to get two people to kill her partner. My lady, in 17.3, Mr. Roux argues that the appeal court did not reconsider the findings of the flight response, but we've referred the court to not only credibility findings, but also the fact that the accused armed himself, walked there, approached the danger with the intention to shoot if there would somebody be there. That's a finding, my lady, of the appeal court. That's a finding that the court should give effect to, with the utmost respect. And that is, he armed himself with the intention to shoot if there was an intruder in the bathroom. And when there was, he did. Those are the findings of the SCA. And I say it with the utmost respect, that this court should give effect to in a sentence, my lady. My lady, as far as 17.5 is concerned, the comment that, or my response to that 17.5.1 would be, my lady, that the Supreme Court of Appeal made findings on 3 occasions that it is unclear why the accused fired the shots, as he explained he did. And those are findings, my lady, without misrespect, that this court will have to take into account. My lady, as far as paragraph 20.2 is concerned, my lady, it doesn't mean that I do not have any difficulties with other paragraphs.
What are the...
20.2, my lady.
What's the page?
Page 20, my lady.
Page 20. Thank you.
I found that interesting. The accused has punished himself and will punish himself for the rest of his life far more than any court of law can punish him. My lady, it's unclear how the accused punished himself. But I'm convinced that any person that stands accused of murder and is convicted of murder feels that he's done himself in. That wasn't the thing to do. How he punished himself, I don't know, my lady. But what I do know is, I know how Mr. Barry Steenkamp punishes himself to feel the pain. That is a broken man that gave evidence before this court. My lady, at paragraph 27, page 24, my argument here is, my lady, our argument is that the accused's version was rejected by this court. The appeal court made, on 3 occasions, findings on the credibility and a probable or possible version of the accused and said that none existed. Then paragraph 30, my lady. Paragraph 30, my lady, I really just don't understand. We respectfully submit that Mr. Steenkamp's pain was compounded by being exposed to an incorrect case presented by the state that the accused had a direct intent to kill the deceased. How can that be said? Based on what? It's a respectful submission. Based on what, my lady? Not on the evidence at all. Not evidence led before this court. Not on the evidence of Mr. Steenkamp. Not on the evidence of Kim Martin. So on what would they base that? How would they be able to submit something that there is just no basis for whatsoever? Because, my lady, as we argued, if that was true, one would have expected anger towards the accused by Mr. Steenkamp. There was never anger towards him. There was grief we saw, shaking hands we saw, but never anger. The best he did for himself as a father said, he must pay. That's all. He did not tell the court to send him away forever or anything like that. So he must just pay. Now that's not anger or hatred because he would think that the state would present a case of direct intent to kill. It just does not follow. My lady, as far as Professor Scholt's evidence is concerned, and that's dealt with at page 26, we have dealt with most of it in our heads. But we reiterate our argument that it is one-sided, it's not objective. That was perhaps the purpose of it. If it's the purpose of it, let us just identify it as one-sided and not objective. What bothers me most is by his report and sweeping statements about incarceration and solitary confinement. That affected the objectivity and the value that the court could give to Professor Scholz's evidence. My lady, may I refer to page 36? There is just no way, my lady, and I say it with the utmost respect, and I argue that the court will take into account that the accused's perception was that he and the deceased were in danger, and that was fortified by an open bathroom window, not on the SCA decision. On the SCA decision, in dealing with putative self-defense, the court dealt with it quickly and decisively, indicating that there is no chance of it's one of those things you mark it and you can get it at any moment if you're not on your feet. But I will get it now. The best the accused can do, as far as paragraph 70 is concerned, is to follow the findings by the SCA. Consequently, although frightened, the accused armed himself to shoot if there was someone in the bathroom, and when there was, he did. In doing so, he must have foreseen and therefore did foresee that the person he was firing at behind the door might be fatally injured. Yet he fired without having rational or genuine fear that his life was in danger. And that's paragraph 54 of the judgment, my lady. And in the judgment as well, Justice Leach made it clear that in the accused's evidence, we testified that he never intended shooting at the person that might have been the danger, excluded him from period of private defense. Because that is the one aspect that one would expect in period of private defense, and that would be paragraph 53, my lady. The immediate difficulty that I have with the accused's reliance upon putative private defense is that when he testified, he stated that he had not intended to shoot the person whom he felt was an intruder. This immediately placed himself beyond the ambit of the defense. Although, as I've said, his evidence is so contradictory that one does just not know his true explanation for firing the weapon. But, my lady, it's just outside the scope of putative private defense. My lady, at 70.7, page 37, in fact 70.8, the defense would want the court to take into account the downward trajectory. We go a bit further, my lady, say the court accepted the evidence of Mr. Mangena. Mr. Mangena testified on the angles of the downward trajectory, but more importantly, is evidence that the deceased stood in front, right against the door, facing the deceased, is a fact that this court accepted. And that is perhaps more important than the downward trajectory, my lady. We dealt with in our heads that the mere fact that he could have aimed higher or lower has to do with the difference between those directors and those provinciales. But the more important aspect is the evidence of Captain Mangena. My lady, where we deal with paragraph 76, page 39, there's a submission that the aggravating factors resulting from the finding of the SCA do not outweigh the reduced moral blameworthiness. My lady, I just don't see them at reduced moral blameworthiness. Not on the facts that we have before us. The facts we have before us, my lady, that I've dealt with in paragraph 10, 13, 14, and 19 of our heads, is a person with intent approaching the bathroom and firing the shots through the door. My lady, that was a quick glance at the heads of the defence. I then conclude by saying, my lady, that we feel that a long-term imprisonment and the minimum sentence should be imposed. My lady, may I inquire if the court will make an order today about the photographs, or will the court make it?
I've got a question to ask. Are you not asking this court to extend the scope of these proceedings.
No.
We are here for resentencing,
Yes, my
for
lady.
sentencing afresh.
Yes, my lady. The court can, at any time up until sentence is passed, the court still has the power to deal with any order made by
No,
the
no, I'm not saying I can't do it. I'm
Yes.
saying, are you not extending the scope of these proceedings? The purpose of these proceedings
Yes,
are to sentence afresh.
yes, my lady. Yes, my lady. My argument to that is, my lady, in leading evidence, in aggravation of sentence, a witness requested this court to allow photographs to be made available as part of the process. It is inherent into the, as part of the process. It's sentence. The father gave evidence. He requested this court to make that available as part of this process, my lady, not as any other process. In sentence, that's what he wanted. So, my lady, if those were perhaps evidence led in the previous trial, and we cannot revisit it, that I would have said would be extension of the scope. But it happened now, my lady. It happened whilst we're busy with the resentencing of the accused. A witness testified now. And therefore, my lady, I'm confident that the court, and I say it with utmost respect, has the power.
No, I didn't say I
judge-
didn't have the power.
Yes. And also confident that it's not outside of the scope of these proceedings, my lady. It's part of the, because, my lady, may I argue that part of my argument is that the court should have access to the photograph. The court itself should perhaps revisit, like Mr. Roux wanted us to revisit certain things. The court should revisit certain things in sentencing. If that is my argument, that 4 bullets tore through a body, that the court should take that into account as an aggravating factor, then I've made this part of the scope of these proceedings, my lady. And I have. I've said the court should take into account what happened to her while she's in that cubicle. It's part of sentence. That's my argument on the scope of the proceedings. It happened during our sentencing a fresh sitting, and I agree that the court has the power to do that. I just say that it's within the scope.
Thank you.
Yes, my lady.
Thank you. Yes, Mr. Roux.
Thank you, my lady. I won't be long. My lady, as to the application, I think it should be a substantial application. There are so many interests. You're the upper guardian of children. Would that be in the interest of children to look at the photos? I understand what Mr. Steenkamp is saying, but it's a separate application with separate merits, and it needs separate input. And the court's the upper guardian, and I'm not saying the court does not have the power, but I don't think it's the appropriate stage. You're here for resentencing. That's a proper application that can be made, and submissions made, affidavits filed, and interested parties can then be present. But it's got wide ramifications, and I don't think it's appropriate to consider it as part of this. As the upper guardian, must children look at it? How will we stop children from looking at, and what is going to be achieved? I think it must be properly ventilated by all parties concerned, my lady, and this is not appropriate, the appropriate time. My lady, I will do a reply in the true sense of a reply. The state says that our paragraph 31 does not make sense, where we said that the pain of Mr. Steenkamp is exacerbated by the fact of the state scenario. Well, I have two answers. The first answer, if I may read paragraph 18 of the Supreme Court of Appeal judgment. then it will become clear.
1 minute, I got distracted. What paragraph were you referring to?
I'm sorry, there was reference to paragraph 31 of my heads of argument, page 25.
31.
31, page 25, paragraph 31, my lady. And he says that.
Thank you.
And my lady, two answers. One is, if I may read paragraph 18. Paragraph 18 of the Supreme Court of Appeal judgment, the first part says the following. It is not necessary to examine the accused's credibility in any greater detail for purposes of this judgment as, despite the deficiencies, the trial court concluded that it had not been shown that the state's version that there had been an argument between the accused and the deceased which had led to her fleeing to lock herself into the toilet and him then shooting her through the door was true beyond a reasonable doubt, and that the state had not shown that the accused had fired at the toilet door for any reason other than he had thought there was an intruder behind it. He says that's the trial court's finding, and it's not for me to reconsider that. Now, that's important. The whole state's case was premised on those directives on this alleged, purported argument and fleeing. When Mr. Steenkamp gave evidence, he was stopped. He said, I still believe there was an argument. And that's the point we're making. That's the point we're making by presenting that case, which had no merits, that you exacerbated the emotions. It's in that regard. Then there was reference to paragraph 70.6 of our heads of argument, page 36, where it was his perception that he and the deceased were in danger was fortified by the following. Those are the court's findings, the trial court's findings, and those findings were not disturbed or reconsidered by the Court of Appeal. That's where it comes from. It's not something that we dream up. Of course it's important, it's part of sentencing. My lady, the Professor Scholes is now criticized to say, you only look at the accused. We have to bear in mind that the same facts remained. It's a matter of interpretation on the facts. There was no new evidence before the Supreme Court of Appeal. So it's already all the other factors relevant to sentencing are before the court, and the only outstanding thing was what has since happened to the accused. It is that perspective that Professor Scholes was asked to say, just do the analytical process and tell the court from what is now the position with the accused. It's not a fresh sentencing report. All those factors are already before the court. It's not a new case. It is just to deal with that aspect. And that's, then you cannot say it's biased. Then you cannot say it's not objective. It is objective. It is only that part and no more. It was submitted to you that the Versaghi case, and I don't want to go too deep into the Versaghi case, it was more to explain to the court what's happening here. That was not a matter, that's not applicable. Of course, someone was driving away. He's not in danger. He fired shots when he should not have. It's the same. Then the state says that the accused intended to kill the deceased. Now, we have to be very careful here. It's a constructive intent. I'm talking about the factual intent for purposes of moral blameworthiness. Because the deceased remained a party in the indictment, it was not a person unknown or a person behind the door. So when we look at sentencing and moral blameworthiness, we have to look at how did he feel about the deceased and his intentions against the deceased. And then you look at everything in context. And then you understand that he's subjected to the legal construction of intent, that you cannot in law escape liability. But that does not mean that his beliefs are just eliminated and negated. They're still there. And that's also in paragraph 18 of the Supreme Court of Appeal judgment. That's the factual finding. And lady, if I carry on, I will abuse the process of reply. Those are really the main points in law relevant to it.
Yes.
Court, my lady, with the utmost respect, we usually...
Excuse me, lady, I'm not
Oh, I thought you'd done.
sure what the process is.
No. I allow him to reply only to the application. I'm not sure what he was...
Yes, to the application then, of course
Yes.
it's right, my lady. I was not
That's-
sure. I was still standing and he was talking and I...
I'm so sorry. I
Yes,
thought you
thank
had,
you.
you
Thank you,
had
Lord.
finished.
No, I am now.
I can assure Mr. Roo I will not get up if the court did not recognize me. And he should know that. The court recognized me and that's why I got up. And the court's 100% correct. I want to deal with the application. My argument is, Mr. Roo is not even part of that application. We as counsel, when we don't want to deal with something, we always say, let us bring a substantive application. Well, it's not that complicated, my lady, with the utmost respect. Those photographs were
But
handed in.
what if I agree with him?
Then, my lady, if the court agrees,
Yes.
the court may say it should only be shown in court or whatever. But if the court agrees, my lady, it would be as the other exhibits. My lady, Exhibit E was available to the media, except these photographs were taken out. It was handed in. So all we're saying is, those that we excluded, it was handed in as exhibits. It's a public document. So all we're saying is that it's a public document. The interest that we protected was the integrity of the deceased. Now, the deceased parents are here. They are legally represented as we stand. I've had consultations with all of them. That is their view, my lady. So if there's a substantial application, who would be part of that? Lady, may I just say that if we make it available...
You know, a substantial application doesn't have to be opposed. You know that.
Yes.
Yes.
But, my lady, but then I can answer any question. Then I'm bringing one. And I can answer any question. Lady, because if we say it will be made available, what people do with it, my lady, they have to bear the consequences. In making it available, we're not showing it to children. The court's not showing it to children. The court can even caution people not to do that. My lady, and I purposely did not want it to be on television or on the screens like we had. It's an application, my lady, just to show what happened to the deceased. It's a public document. The publishers or whoever want to use it, they take responsibility for what they do with it. And I believe they're responsible. From the parents' point of view, my lady, and from the state, we think it's time, as I'm quoting Mr. Roo, it is time that people would see what those bullets did, what this accused did. That's my application, my lady. If there's any other aspect, I'll address the court on it. I'll even take instructions, my lady, because the interested parties here, the court is the custodian of it. The integrity that we wanted to protect was that of the deceased. And, my lady, more so, the mother of the deceased. I brought the application because the mother of the deceased was in court. I didn't want her to see it. That was the protection that I wanted. She's now given her permission. That's my argument. I'll deal with any questions that the court may have, my lady. And I realize it's not an easy decision.
Thank you. I need to I will think about it.
As a court pleases?
I need to go and get a date when I'll be sentencing.
Yes, my lady.
So for that reason, we shall adjourn. What is the time?
It's 3:45, my lady.
3:45. We shall adjourn just for the purpose of getting the, the date. If I can't get the date, I'll come back and I'll give the date on Friday.
As a court pleases.
But if I can get it immediately, I'll do so.
As a court pleases.
Meneer Langs, we staan nu op Rising Court. Soekomani. Quiet, ladies and gentlemen.